Everybody all set? Okay. Hello, and welcome to the edition 2 of the February Zoning Board of Appeals. It's February 25th, 2014, and we have some continued applications from our last Thursday meeting with a further continuance on one of them. Right, Nicole?
I'll read that one. First application was continued from February 20th, 2014. David and Mary Ellen Bridgewater of Silver Landing request a special permit in accordance with section 60.2 to erect a two-story detached garage within the salt marsh entitled Land Conservation District and property located at Sudbury Lane.
Okay, so we received a request from the applicant's representative, Mr. Morris, requesting a continuance until the next meeting, correct?
Correct.
Okay. Can I hear a motion?
Move to grant the continuance until the March meeting?
March 20th.
March 20th meeting?
Second.
All in favor? Aye. Okay.
Our second application this evening is continued from February 20th, 2014. Leonard and Virginia Tubelis. I'll never get it right. Of 99 Jacobs Lane, West, MDL Chapter 48, Section 6, special permit finding to expand the pre-existing non-conforming single-family dwelling unit and present property located at 55 Holly Road.
Okay, so, Mr. Morris, you identify yourself for the record?
For the record, Gregory Morse, with me is the property owner, Len Cupelis. This was continued from the other night so that the abutters could have a chance to review the application that had been submitted. I don't believe that the board had asked for any supplementary information since that time. This is in addition to an existing non-conforming dwelling. As you recall, the dwelling exists 3.6 feet off of the front property line at 55 Collier Road. We're proposing an addition that complies with a 5-foot front yard setback. With relationship to the side lot line, the side lot line is 15 feet required in the district. The addition is 15.2 off of the side lot line.
And did the board have, anyone in the board have any additional questions for Mr. Morris or Mr. Cubelis, based on what we received? Okay, is it all right with you? We go right to the audience? Okay, so is there anybody here that wishes to be heard on this application?
Yes, Madam Chairman. My name is Walter Sullivan. We were at the hearing on the 20th and indicating the intention to provide the board with some background information. And I've submitted to the board a list of 7 items which appear to be inconsistent with the provisions of the bylaw. Item number 1 suggests that there is an ambiguity at best with respect to the setback, the front setback from the street, because it turns out that that 3.6 is only a very small part of the portion of Collier Road which has become part of the building foundation itself. And so that's why in our submission to the board with copies to the applicant, we indicate that when you're coming down Collier Road, going past approaching the subject property, that there is a plan reported showing that the street width is 35 feet. And in reality, it's a lot closer to 8 or 9 feet, which has actually become part of the front yard of the subject property. And we've submitted with our list
Yeah.
an observation, a photograph going uphill and showing the confusion about what the property is.
Do you want us to talk about each one as you go, or do you want to just give us,
Whatever you think, man.
okay, why don't we, since there's 11, no, wait, I'm sorry, how many, 7 you said? 7 different items? Let's go through them one at a time. Mr. Morris, can you show us on your plan where the street layout is? Just point it out so we're all on the same page there.
So the street layout is a 35-foot wide right-of-way. You'll see it's represented by this
This
line
is here,
as well
I
as
think.
this line.
This is the
Mr.
property
Sullivan is
line.
talking about the pavement, which is inside of the right-of-way. The pavement is approximately 20 feet in width, which is interior of that right-of-way.
Okay. Now, in this, we received a photograph of a fence. I show it. Where's this fence on your plan?
So the fence is
Show 'em right there.
right here, just off the edge of the pavement. It runs between the 2 driveways of this property. It was there prior to my client owning the property, but it is located in the right-of-way.
Okay.
I would note that is typical up in that area for people to have vegetation and lawns out to the road. And I have several examples of plans that show portions of fences out in the right-of-way.
Okay. But nevertheless, you're, for purposes of this project, though, you have calculated the frontage at the roadway,
At the right-of-way.
at the right-of-way. Okay.
So the issue here, I think, and I'm willing to be enlightened if I'm misstating the issue, the dark orange part is the proposed addition, right?
Yes.
And there's nothing there presently?
Right now, there's part of a walkway to the existing house. There's some lawn and some landscaping where that is.
Okay, so then the issue, I think, is to what extent, because I think we already agree it's a non-conforming property, to what extent, if any, does the proposed addition increase a non-conformity, correct? So can you address that?
The nonconformity here is with respect to the front yard, the existing structure at 3.6 feet, the proposed is at 5 feet, so it's not an intensification of that nonconformity.
Well, except that you're going across, so in that sense, you would have to agree. I would hope you would agree
Yes.
that is an intensification, but it's not going further out. It's not
Correct.
closer, yeah.
It's not closer.
And Neil, do you have any comment on the issue of the fence?
No, but I would just, I think we're looking at an extension of a nonconformity,
Yes.
and I don't know if the board has made a finding that it's an intensification.
Well, we haven't made any findings yet, so,
Right.
Yeah.
So, exactly. So it's an extension that, whether that's substantially more detrimental. I mean, it's an existing fence?
yeah, it's,
Is
did you
it
see the
6
picture?
feet?
It's, I don't know, can you measure? It looks like.
Looks
how
like
many-
about 6 feet.
About 6 feet.
So it doesn't require a building permit, and we don't regulate fences under the bylaw.
But it's in the roadway, is the issue, so
And
it's.
I would agree with Greg that this is 2,000 properties in this town with
Right.
structures in the, not structures, fences, mailboxes, lawns, including my own, shrubberies in the right-of-way.
Yeah. At the very least, it's sort of not an issue for us tonight.
No.
As I see it.
It's more of I think it's a Board of Selectmen issue. If they wanted to put a sidewalk in, they could certainly take the fence down and put a sidewalk in. It doesn't, the property owner cannot take the town's land by adverse possession, and is it a safety question? That's not my jurisdiction, nor do I think it's the board's. And typically, we do not get, don't ask for, traffic studies for single-family dwellings.
Right.
I mean, 20 years, I've never seen it happen once, so. And we have a bylaw that, which is enforced by the police on obstructed view on intersecting ways, but none coming out of your driveway.
We have, I probably don't have standing on this, in voting on this because I missed the first meeting, but
Correct,
I'm
yeah, but-
contributing some insight, if I may. The proposed addition is not a garage addition, correct?
Correct.
The garage exists currently on the opposite side of the property, the northeasterly side?
Correct.
We have in the past, I think, Neil, you can probably agree, when people have come before us to put a garage addition on a property that's non-conforming, we try to keep that garage as safe as possible. We've suggested it be brought back
Yeah,
for sight
I didn't mean
lines
to
and
say
things.
we're not, safety isn't a concern.
We do try, but
We're
again, that's not
we're
being,
experts.
but that's not being asked
Right.
here to create a new site, potential site non-conform, or site issue or anything like that. It's the addition that's in question doesn't address that concern, or that concern doesn't address specifically the addition.
So, I'm not sure what we can do for you, Mr. Sullivan, or your neighbors, because it's just not an issue that is really before us on, that issue is not before us, it's not relevant to our discussion tonight.
Well, I think it may be because I couldn't find any records that indicated using the town's, a portion of the Collier Road for the front yard.
And that may be true, but it's not, we don't think it's germane to the issue of whether or not they put this addition on. It's not, the addition is not encroaching upon the right-of-way. It's set back. I don't think it's going to head anywhere for you.
No, I question whether the so-called addition is exclusive of the front yard that they have, that shows on the plan, because that's also the access way to the garage. And there was also, if you look at that photograph, there is really no way to see, there's no sight distance opportunity when you're backing out of that two-car garage, which is really one after the other as opposed to two in a row. There's a fence there. And so they're trying to back out, and it's actually going to be a dangerous situation.
How does the addition change that?
Well, I question whether we're just talking about the addition.
That's all that's in front of the
When we
board.
rolled up our sleeves, we saw that somehow or other, town land is being used for somebody's front yard. There's no evidence that the town gave anybody the authority to use it.
But-
And I remember when that fence went up, I didn't really have any ideas about why there wasn't anything else that happened one day. But as we were looking into this, that's a much larger piece of land. Now, if you're saying that that's someone else's responsibility, then it sounds to me like the building inspector is going to have to make that determination before anybody puts a shovel in the ground.
Maybe, but not tonight.
And just,
Tonight, but on the other hand, if you're going to be making a finding that there isn't any reason why we shouldn't do this, I'm suggesting to you that somebody should be looking into whether or not there's an encroachment on the driveway, because it is much narrower than it was supposed to be. And when we're coming down Brown Ave to get it back on the street, it is a very, very tough situation. And as is indicated in a later point of the 7 points that we raised, I don't even have the faintest idea how they're going to be able to get down back there with all this heavy equipment they're going to need to do this building without interfering with everyone's rights. And that's why I made reference to finding that this could very well be interfered with the travel by the citizens of the town.
Mr. Sullivan, I think you're familiar with the town, and I know you are knowledgeable in the area. The roadway layout of all the roadways in the town is frequently not the same as the paved surface. Is that fair?
I think it's fair to
I
say.
think it's fair that almost every roadway in the town has a paved surface smaller than the roadway layout. Matter of fact, we had a recent issue where neighbors of a construction project were rather concerned that they were losing part of their front yard to a sidewalk. And we listened intently and thoughtfully and then said, but that's part of the roadway layout, it's not your land. But we've been using it, that's fine, it's not your land. And I think the same applies here. The applicant doesn't own the land, but like almost every other house abutting a roadway layout in the town, the applicant has grass or other, as Neil said, mailboxes or fences or whatever, shrubberies, hedges, right up to the paved way.
Stenbeck Place?
That's what I was referring to, Stenbeck Place. We had a pretty agitated group here, and we would love to have tried to accommodate them, but the fact of the matter is their hedges were in the roadway, and when the town wanted sidewalks there, the town wins. And I'm sure the applicant realizes that the fence is only there in as much as the town isn't using that, and like everyone else, he's extended his yard to the edge of the pavement. What would we have otherwise? The town have to come around and put in gravel along the edge of the roadways so that no one can use it and it just stays fallow until the roadway layout gets completely utilized?
Well, let me put it this way. We live across the street. Our house is substantially elevated more than the other houses in that part of Collier Road. We have a significant slope of road of land going up to where our house is. When I looked at the plan back when we were buying the property, I saw that there was at least 7 feet of the layout was actually part of our sloped area. I think what probably should have happened is when the town finally got permission to put in the sewer, to put in the new water lines, that they should have looked at all of this, because they would have been able to, with the backhoe, to have widened the road by 8 by 5 or 6 feet on our side, and also by maybe not the whole thing, but some part of on the other side. And it would have been so much easier because they had already dug everything up. But instead, they decided not to do that.
But again,
now, if you were to come down Brown Avenue, and there's 4 houses up there that rely upon that for ingress and egress, you would see that there's not enough room for how to get through if someone is parked on the other side. And so this could be a danger, certainly a danger to the poor people who rely upon Brown Ave to get back and forth.
and I would suggest
But
if
that's what I was trying to focus on the other night.
I would suggest if the highway department wants to evaluate the road as it's paved within the layout, that's their prerogative. I mean, I have exactly the opposite situation on a property that I own on Gilson Road. It's on a curve, and the paved surface is on my land. They have taken my land for paved surface. They have no right to it. I'm sure if I were to make issue, I could say you have to remove the pavement and adjust your curve to be within the layout. But it's just being a friendly neighbor to the town. I mean, the town being a friendly neighbor to the abutter.
Well, anyways, that is our, that is the reason for us having some concerns about item number 1.
Okay. Is there anyone else who'd like to make a comment? Ma'am?
My name is Barbara Gifford, and I live on Brown Avenue. And my concern, and maybe this is not the right board, but is a safety concern. We're imagining some construction vehicles, perhaps 8 feet wide, on a 17-foot wide piece of pavement. And I'm imagining a school bus, also 8 feet wide, trying to cross, trying to pass by these construction vehicles. And I'm very concerned, or an emergency vehicle, a fire truck. It's a real safety concern, so perhaps you could advise us about what board we should be addressing with this concern.
Well, first of all, I have to tell you that the gentleman's, oh, Mr.
Well, we do have a board called Traffic Rules, and
Okay.
it consists of members of the DPW, Police Department, who report to the Board of Selectmen. And if there are issues that, that neighbors think rise to the level of where they might intercede, they can certainly petition them.
And Mr. Sullivan is about as best a representative as a neighborhood could have, so. Anyone else on issue number 1? Okay, let's talk about issue number 2.
Thank you. With respect to issue 2, when we came here on Sunday, we indicated that we were having some great deal of confusion as to where the elevation is and what the elevation is with respect to adding additional traffic, actually not additional traffic.
I lost my stuff.
Extending the size of the building. And we came to the conclusion that the way that, although the plans don't show it, that there is one page in the plan which does show what they have in mind. And that's the plan that's by Janet's design. It shows on the sheet where you go right side elevation and left side elevation. It shows that they're intending to.
I'm sorry.
I don't think we have those.
We don't have those.
We don't
You
have,
this plan?
No.
I think we gave, I don't know what happened. I thought we had those.
You guys gave us one.
Yeah, we gave them to them to copy.
Oh, we
We don't
didn't,
have copies.
we don't have
No,
copies.
I can give you this copy. I've got no.
Okay,
I made copies, I didn't realize that.
yeah, okay. Okay,
That might be 2 sets of.
is it 2? No,
It's all one set, probably.
that's only one
No, it's
set.
not one set.
It's just one set.
Sure.
Yep,
Yep.
good front. Okay, I'm sorry, so you're talking about right side elevation.
Oh, it's pulled back. That's the existing. Pulled back. A couple of feet.
It's gonna go. Are you talking about the building height?
Yeah, I'm talking about the, what I understand is doing is, if you look at the picture showing the existing building, they're adding on so that they're going to have an additional maybe 20 feet of width going in the opposite direction, going towards,
Towards the back of the property you're talking about?
no, we're talking about it going, there is a bit of open space on the side of the property, which approaches Alice Gallagher's property, which is, I think,
Yeah, this section.
This is Gallagher.
57.
57 Collier Road. And if you look at those, they're really adding on by pieces as opposed to one singular roof.
Oh, all right, so,
And that's the one we're trying to figure out whether or not that's going
Does it have
beyond
front
what's
elevation?
allowed by the bylaw. That is an open space that is now going to be turned into further extension.
how, going beyond what is allowed by the bylaw, as in what? How, the height, or the,
Well, height is a question. There isn't anything shown as to the, what the height is. It's silent, but
well, it's not any higher than the existing building, so, it's existing structure.
Well, it's only is it 2 stories too?
The existing structure is higher.
Right.
Yeah, but I think they're doing a new roof over the existing, but not a.
it's going to be a brand new, at least a brand new roof.
I think they're changing the roof pitch over the existing, but not.
Is there anything that shows the height of the roof?
No, unless it just came in today.
Mr. Morris?
The roof as proposed complies with the 35-foot maximum height.
Okay.
How it's depicted on those plans are to scale. I believe it comes out right around 32 feet in height. It is in compliance with the bylaw.
Mr. Duggan, you, if they get their building permit and bring you in,
They need to
Final
bring in,
plans.
scale drawings.
and you will not be letting them build anything
No,
higher than,
and frankly, just by looking at this, and the height of the windows, and just the scale of the house, it looks like it's, well, not, it's, I don't think they've maxed it out, let's put it that way.
Mr. Duggan will be watching that and making sure that it doesn't go 9 stories.
You'd say they're even putting the windows into the roof.
Yeah.
I mean, so the roof gives more, the roof looks bigger, but what he's concerned about is this exists. And they're adding this section, and they're bringing the roof over,
Yeah.
and it's all about views.
Is that good?
Well, I'm not sure that it's good. I'm not sure it's accurate because we haven't seen any figures.
Well, we don't often require, the level of detail to this board that Mr. Duggan is definitely going to require when a building permit is applied for. So we know that he's not going to allow them a building permit if they come in with a 40 or 45-foot roof height. It's going to be an issue. It does not appear from the drawings that, and these are scaled drawings that have been provided, I don't disagree with you that it's, is that this right here, 34.2?
No, that's the elevation.
Oh, that's elevation.
Of the, where the second floor is from the,
The height of the roof will definitely be within the bylaws, or they won't get their permit.
The other issue of item 2 is somehow or other, portions of that roof are going beyond the property line. They're actually going to be overhanging, at least that's how it appears from the plans that were filed.
Okay, and which plan are we talking about particularly?
I think that's the one that I had referred to.
Okay, do you want to show us where you think it's going to go over the property line? Because I'm not,
The front property line are we talking about? Oh, I kept thinking, looking at the side going, what's he doing? It's this way then?
yeah, he's looking at, this roof line extends out, this roof line extends out, these eaves.
This front elevation
okay,
shows the extension.
But those are just eaves that are typical to the overhang of a roof over the foundation.
I'm kind of missing it. You're
This doesn't
saying,
exist. Right now, this building doesn't exist. This is open space.
correct.
No, that's what we're asking to be built.
Right. And so,
But this is,
It's coming all the way-
but this plan outlines where the footprint of the building is. The fact that the roof line overhangs the footprint you have 18 inches to put a soffit. This is the drawing that we're talking about in terms of encroachment to the public way, or to the sideline, or the front yard setback, and it's, the engineer who's laid it out tells us it's 5 feet from the street. The existing structure is only 3.6 feet from the street.
but they were talking about at the elevation of the road. Here, we're talking about the roof itself, which is now going to be another 15 or 20 feet longer than the building is right now.
That's the building extension right there. That's what's going to be added, this section,
Yep.
right there. And it's going to have a roof on it, and the roof will have an overhang, which will be, is it 18 inches?
18.
18 inches, it can't be any more than 18 inches.
Is not considered part of the footprint.
It's not part of the footprint, it's the overhang, it's the soffit. And that can encroach on the sideline setback without being calculated in. If it was a 3-foot overhang,
Then we'd have.
then it would have to be, the foundation would not be the setback, it would, you'd-
Over 18, that would be an issue, but it's not.
Well, it's, I'll let that one fly.
Okay.
But what is this? Is this showing?
This is
something?
from the back, right?
Yeah, that shows that the existing roof overhangs, and you're correct, Mr. Tibbetts, the proposed roof will have an 18-inch eave as allowed by the bylaw. The face of the structure is at 5 feet off of the lot line.
Up to an 18 inch, yeah.
Yeah, it's not going
Which
to
is
extend.
similar to what's existing now for an overhang.
Yeah.
So this is the front we're talking about?
This is the backyard.
Oh,
Of the
And
existing
this
house.
is, yeah, so you're in the back of the property looking north?
His house.
So,
No,
so
looking
is this
north.
supposed to be, and I don't see any
So-
evidence here of Augie Road.
no, that's the back.
Because this is the back of the house.
That's your house there, Walter.
Yeah.
Greg, do you have a picture of the front of the house?
I did not bring a picture of the front, no.
Okay.
But the roof line along the front is very similar to that. It's carried right around. It's 18 inches, roof overhang.
Okay.
here's what you're looking at, the front. And from the front, it's a two-story building from the front.
Yeah.
So that's what you're gonna be looking at, and it could be 3. Well, depending on how the rear
Okay.
grade affected it.
All right.
All right, does anyone else have any comment on the abutters objection, item number 2? Okay, can we go to item number 3 regarding the proposed patio?
Landscaping item outside of the request.
Mr. Morris, the patio is a deck, is that what it is? Like a deck-like
It's
thing?
going to be a finished patio, probably a stone patio. It does not have a roof overhang over it. It's a landscape feature.
Okay.
Can
And
go all the way to the
so-
lot line.
Not anything that we can dictate, correct?
It's a landscaping features, no setbacks, there's no building permit required. Unless there's retaining walls, I haven't looked at closely, that retain over 4 feet of unbalanced fill. And there's no setback for them either.
Okay.
Building permit because of the structure.
Because it's a structure, yeah,
Right.
but typically landscaping features aren't.
All right, so item number 3, the patio is not something that is within our purview. He can patio his entire yard, and no Section 8 20.
Conservation might not like it, but.
Yeah, that's another deal, but that's not us. Any comments from the audience about your number 3, or do you want to say anything further?
Well, I did have a conversation with the applicant this morning. He pointed out some things about the patio that I was unaware of. But it still seems to be very close to the adjacent properties.
And I think what Mr. Duggan said, he could put a patio right to his lot line. It's not dictated by any zoning bylaw.
Well, I think maybe that would be true if we were talking about a lot that was available for building a home on. But we're talking here about adding on to the building. And the standard is that it shouldn't increase it should not be any more detrimental to the neighborhood. And all of these houses, even on both sides of the Collier Road, close proximity. And this patio is going to be real close to Gallagher's home. It's going to be real close to her daughter's home. And it's going to be pretty close to my home because everything's so narrow there. Usually when people have patios, they try to have them at some point so it's not going to be causing any difficulty to the abutters. That's what our thesis was.
Okay. Well, again, it's not something that, if, whether he builds his addition or not, he could put a patio right up to the lot line, and we would have no control over it, so. What about, and I think we've really talked about number 4, about the safe site distance for the 2-car garage.
Yep.
They are not altering the 2-car garage in any manner, correct?
Correct.
Okay, so it's an existing issue. If the neighbors feel that it's a safety issue, and I think that they'll have to go to a different board, and I certainly don't know which one. There's a number of them, but it's certainly not something that this board, in this application, if they were doing some changes to the garage, I think then we could consider, if that's something that needs to be addressed or not. But because it's not part of their application, they're not going to do any modification to the garage. It's not anything that we can dictate at this point.
The drawing of the garage on that front elevation page of the plan that I gave you shows something different than exists.
Okay.
There's a single door. On this proposal, there's 2 doors.
It's one door to me, look to.
What's the, no?
I think it's
Yes?
the design.
That's correct. It's a single overhead door.
It looks like, I think the design makes it look like 2 doors, but it's actually 1 door.
I see.
So they're just going to replace the garage
Look
door?
at the width of the gate and the width of the door of the garage. That's only a 1-car garage door.
Okay. All righty. Anybody else on number 4? Or we know where that's headed? Number 5?
Well, item 5, it's really part of the whole story. You don't have any dimensional information on any of the plans, but you don't have anything at all that shows,
The square footage?
well, that shows what is the gross living area. They're saying that they're looking for more than 20% increase, but they don't say whether they're looking for how much of an increase.
That is something that I would like to see on the plan, that you can, yep. Or do you have something to submit?
Yep, we actually prepared a spreadsheet that has those figures
Okay,
that you're looking for. Existing finished space in the house, floor area is 2,075 square feet. Proposed finished space is 3,021. There are portions of the basement, as shown on,
Included in it.
yep, as shown on here, that detail what's to be finished and what's not to be finished. They're all dimensioned and they are all to scale. I'll submit that.
thank you. Do you have a copy for our friends?
We can certainly send him a copy if we don't have one.
Okay,
I'll leave one for the file.
Okay.
okay. That's good. And so, total increase is,
946.
in terms of percentage,
45.5%.
45.5?
45.6%.
John did it in his head.
I have a smartphone.
Okay. We'll pass that around.
Good job, John. Well done.
Okay. Is that something, I think we've seen that on plans before. Is that, I don't know whether there's a standard in doing your plans?
Yeah, I can certainly add that.
That would be helpful if you could do that.
Okay.
Okay. And number 7, I'm jumping ahead. Number 6, the property line separation from 55 Collier Road. I thought I saw it. I mean, am I not understanding that this is the, oh, this is 57. Where's 55?
You're correct. This property here is number 55.
Right.
The
Oh,
subject
okay.
property. That bold line represents the property line, and you see a dimension of 15.2 from the addition to the property line.
Yeah. Do you understand that? This is the property line. Okay. And number 7.
I have a question about that.
Sure.
Is the property line marked now?
Yes.
I mean, not there, but has the surveyor's marks been placed?
Okay. No, you're asking me if it has
Yes,
been?
I'm asking you.
I
As
have-
in
I have no
permanent
idea.
markers?
Yes,
They're not required.
they're not required.
No, the surveyor would have put marks down so that they were able to survey the property, and there may still be some stakes there or some found drill holes, or, I mean, I haven't looked at the plan specifically, but they're not required to bound the property.
And the surveyor would have been hired by who? By?
The applicants.
He's here
So
before
they're
us.
not- So then, okay.
I'm sorry, did you identify yourself?
Yes.
Okay. You did not?
No, that's probably.
Okay.
Can I get her name?
Ma'am, could you please just give your name for Nicole?
Barbara Gifford.
Okay. Okay, and number 7. We understand your concerns are that you're concerned about the demolition and construction access to 55 Collier Road and contractor parking. Mr. Duggan, I look to you on that because you're kind of in the heart of all that all the time. How do you deal with those issues?
Same way I do with landscapers.
It's hands off. If there's a problem,
I mean, I think, I mean, it's a good question, and it's, there's a lot of tight spots around town, and, you know, it's, parking in a public way is the jurisdiction of the police department, and, you know, there are cases where people have to get police details if they have to, but that's not something that I would decide. And I really don't have a regulation that says you cannot park in a public way or private way for that matter. So I'm just going to say it's, you know, it's a, it's we have a lot of non-conforming lots in town, a lot of narrow roads, and a lot of construction going on, and it's a big inconvenience, no question about it.
And it requires good neighbors on both sides, good neighbors who are interrupting the usual flow of traffic, and good neighbors that sometimes realize they have to put up with some stuff, just as if they were doing work on their property, they may have to, their other neighbors may have to put up with some stuff. So if it becomes a safety issue, again, you know, there is always the police department to be dealt with, but I'm sure Mr. Cubelis is going to be concerned about that himself.
Question, okay.
Yes, ma'am.
Regarding that, there's already been an incident with the contractor.
Oh, you just have to say your name every
I'm
time.
Barbara Gifford.
Okay.
Contractor, a few days ago, driving over the property of the person next door. And, you know, when the sod is wet and you pick a big pickup truck across it, it makes kind of a mess. So it is important that, you know, that be respected.
Absolutely.
Thank you.
And the first person to talk to is probably that contractor or his boss,
I'm not
because
really-
the contractor does not want to be going around repairing everybody's yards after this is over with, but it does happen, and sometimes it has to be fixed.
I have spoken with him. so.
Okay, that's good. He doesn't want any problems either. He doesn't want your yards ruined. Does anybody in the audience have any other comments regarding this application? Yes, sir.
Alex Alfred. So does it have to go through the North?
I'm sorry, one more question. Your address?
15 Colony.
Okay.
Does it have to go through the North River after you guys?
I don't really know the
Or is
answer
it
to that.
outside? I was just outside. and I don't know.
We have a list, Greg, did you research that?
I haven't looked at your list. We believe that this is just outside of it. That's kind of our next step in permitting is
Yeah, so
conservation.
I would, before I issue a permit, I think we're so close, I would require a letter from the North River Commission that it is not in it, okay?
Okay.
So you can work on that.
Does that answer your question? Okay. Anyone else? Yes, sir.
Yeah, Pat Gallagher, conservation agent. I was just going to say they will be filing with conservation on this, strictly within that jurisdiction, so with the hearings.
Okay. And Mr. Galvin, I noticed you had sent us a note that said it needed to have coastal resource areas delineated. Do you need that on this plan?
Only for when it comes to conservation.
Okay, okay.
So some of our jurisdiction lines, 50 feet, it's a few feet here or there, so.
Okay. Mr. Morris is nodding his head. He will be prepared. Okay. Anything else from the board in terms of questions for the applicant, comments? What is the board's pleasure on how to proceed?
Frank, what do you think?
I'm just, every time I have to read the scale decision again, and then,
Well, it looks like you had it ready there, so.
but I do have it ready, and I guess, just to go back, the only question I have is while the setback from the front property line isn't intensified, there's a extension, because you're extending laterally,
Right.
there's a structure that's now closer to, there's a structure that's in this non-conforming range that wasn't there previously.
Correct.
And I'm not sure how if we've gotten an issue like that. Most of the ones that I can remember so far are building within existing footprints and going up. It seems to me, is this an intensification?
Yeah, if there's an intensification, I think you have to determine then, is it substantially more detrimental to the
Right,
neighborhood?
yes. My question is it
Yeah, okay,
an
yeah,
intensification? I'm going through the first step first.
I would argue it is, because you are going, at least, you're extending you may be reducing the reducing the nonconformity, but you're at the same time intensifying it by going laterally. And I think that's the safer way to go, because, then it gets us to the second one.
Is it a one-story porch? Is that what that is on that side?
A portion.
Part of it is a porch.
Yeah, okay.
Yeah. So I think under Gale, even if we say yes, then we have to find that there's no substantial detriment.
Right, and I'm just asking because we're going to have this come up again.
Right.
So even when somebody is moving back, and so reducing the nonconformity, if they're expanding the width of the structure, we're going to consider that an intensification of the existing nonconformity. Is that right?
I'm not sure we always should.
That's why I'm
And I
asking.
think because I'm thinking of some applications in the past, we had one where the nonconformity was on a sideline, and the folks wanted to extend to the back, the rear line, 10 feet or whatever, and it was in order to extend a kitchen. Now, it is an intensification, if you go by the argument that any extension is an intensification, but on that particular application, I'm trying to remember exactly where it was, they had no other choice.
They went from 7 feet to 6 feet.
Right.
That was.
Well, that's a kind
Clearly.
of, that's your word you like, the de minimis.
Well, no, but they were moving a little bit closer, and they were extending it back, and wasn't an intensification. It was, at the same time, they had very little else they could do in the particular property. So that became an issue that,
Did we decide that it was not an intensification?
this was before that was
It was before.
That was
I think that was
before that was
before
caused as celeb. But I think there have been times that I've had applications before me that even though it was an extension of an area that was non-conforming, as is this, it wasn't necessarily an intensification. We can find whether it's an intensification or just an extension. If we find it's an intensification, we should do it on an individual basis, would be my thought, as opposed to saying anytime you extend, it's an intensification.
And so how would we distinguish between those that are and those that are not intensification?
It's an opinion of the board. When you get to.
Yeah, I'm a lawyer. I like to have a
You're looking
rule.
for
I don't think,
a definition of.
I don't think you can have
Right.
rules, because the whole reason we're before the board is here is because there are unusual circumstances on each piece of property. When you have contour to property, when you have, for example, we had an application before us that had wetlands encroaching upon it because of an unmaintained concrete pond, which had become a permanent wetlands. That was certainly unusual.
Yes.
So those things, I think we have to leave it to each case. I'm not suggesting whether to find this as an intensification or not. I just don't think we should make a blanket statement that an extension is an intensification.
Well, one of the cases I looked at today was Goldhirsch versus McNear. And there's a section in there that says, in Willard, an addition which would protrude beyond the existing footprint, everybody knows Willard, was found to constitute an increase in the non-conforming nature of the structure. However, we see nothing in Willard which supports the proposition that there will never be an increase in a structure's non-conforming nature where the proposed alterations are confined to the existing footprint. So I read that is that you could stay within the footprint, go up, and still intensify.
Still have an intensification.
Right. So it seems logical to me, if you go beyond the footprint, you've got an intensification. But, it just, I don't think that gets us one place or the other. It just says we have to make the next.
Well, and I think I agree with Ed with your idea that at some level, there's going to be a case-by-case basis
Right.
determination that we have to make, but I think it's the second step of the test here. That's the more subjective of the two.
Right.
And so I'm just wondering, because it seems to me the first step, whether the proposed alteration or addition would intensify the existing nonconformities or result in additional ones, is a black and white, because if you answer that it does not, then the permit's automatically granted.
Correct.
And so I'm
You're saying that we have the intensification.
Yeah.
We have the
So-
right to look at the nature of the intensification and
So it's safer
vote on
to,
that.
it's safer to generally err on the side of intensification.
To say that, yeah, and I
agree.
I was leaning that here, but since this is only, we've only done this analysis a couple of times now, I'm thinking that, I just want to be clear, I don't think we've had a case like this yet. So even though you're not getting any closer to the front lot line because you are expanding the width, and so you're going to be closer to the front in a place that you weren't before, I see that as an intensification. So, so that people know where I'm coming from on my motion,
Okay,
okay?
all right, so,
Which will, give me a second.
all right, so just double check. Anybody else have anything else to say on the board?
No, I agree with the
Okay.
intensification.
Do you have applicant, people in the audience? or
Okay.
anything?
One more thing.
Yes, well, if it were an intensification, it seems that for that portion of the house, the fence could be set back the 36, the 3 feet or whatever it is from the road, and that would eliminate that problem.
It probably would, but again, the issue of the fence is not before us. The issue of the fence is,
Okay.
is,
I just
is
wanted
is
to
a, is
throw that
a,
out.
is an argument for, first, not an argument, but maybe a conversation with your new neighbor, and then if that doesn't go anywhere, you know,
And you might find
then Mr. Sullivan has more work to do. So,
and the applicant might find during construction that the fence might be removed for the work to be done.
yeah.
Some of it's gonna have to be done anyway to get it.
To get there.
So,
All right, do we have a
All right,
motion?
if we do. On the application of Mr. and Mrs. Cubelis requesting a Chapter 40A, Section 6 special permit or finding to expand a pre-existing non-conforming single-family dwelling by more than 20% for the property at 55 Collier Road as set forth in the site plan by Morse Engineering dated January 23rd, 2014. I move that the board find that the proposed alteration or addition would intensify the existing nonconformities or result in additional ones, but that the board find that there is no substantial detriment and allow the permit.
Any discussion? I would just simply add that prior to receiving his application, the applicant will cause to have his square footage numbers on his plan.
And I think we need to make sure all the elevations that have been circulated around are in
Yes.
Nicole's file.
Yes. We have a second? All in favor?
Aye.
Opposed? Okay,
Thank you.
Thank you very much.
sorry?
You wanted allocated.
He's going to put the square, increase, in this existing and increase in the square footage on the plan.
Thank you very much.
Oh, you got the draft?
We prepared a draft for you electronically.
yeah, it came in the email.
I didn't see it, I don't,
I think it was probably the fifth
I'll
one.
take that.
You know what I mean?
Yep.
Yeah,
I'll be
I
there
think it was
tomorrow.
the one last month.
it's at my office till like after 6:15. You can see it.
Thank you very much.
Who seconded that?
John Hallen.
I was non-voting.
And,
Well, I guess we don't have the answers already.
all right, so I just want to get my stuff out of the way. All right, so our plans are back online here. Did you not have these, Nicole?
I did not,
Why
no.
don't you give them to her? And hopefully you have everything else. Oh, and this is also for you. This has also been submitted.
Which one is next?
Looks like Walden Woods, I would guess.
It's cold outside.
I'll be back in 1 second.
And this, could you give that to Nicole too? Because I think that's hers. That might be her original.
That was my extra, I printed it.
Oh, you printed a copy? Full copy?
78, want to turn the air conditioner on?
It is hot. in
You
here.
gonna crack a window?
Look at that.
This she did not have. Put that in there.
No, they've got them tape shut. Tape shut.
All right.
Oh, that must be insulated tape.
Turned off the heat.
Oh, wait a
All
minute.
right, so.
Here you go.
This is Walden Woods, this is Stockbridge, this is Walden Woods, this is Stockbridge.
Did I get something on that last week?
Sorry?
Walden Woods,
Yes, we had something
last week? I just need to know which file.
I know. Okay, when Nicole gets back, we'll forge ahead. Is that you, Mr. Duncan? Trying out for American Idol or something?
Why?
You're on TV, whistling? Is that you?
Yeah, that's what I was doing.
Okay.
Old American Idol.
Our third application this evening is Walden Woods LLC, request for minimum monitoring agent for the comprehensive permit issued to Walden Woods project of January 16, 2003. The project is located off 45 West Freedom Park.
Hello?
Good evening. For the record, my name is Robert Devon, and I represent Walden Woods, the applicant.
Okay. And what can we do for you tonight?
In recent memory, as a matter of fact, last November, actually October, you modified the comprehensive permit at the request of my client to name Mass Housing as the monitoring agent. What we're here tonight to do is ask you to reverse that decision. This project was originally filed in 2001. Mass Housing never had a role in 40Bs at that time, and their role commenced with regulations that took effect August 1st, 2002, and only covered projects which were commenced by filing an application after that date. I've spoken to town council on this, explained to him what it involves from the town's point of view. What it involves from the town point of view is that this board, on behalf of the town of Scituate, when the project is complete, will retain the services of an accountant or other professional to review the cost certification which is prepared by my client's accountant. Whatever cost the board incurs in doing that, obviously will be reimbursed by my client. To the extent that your consultant disagrees with our accountant in terms of the cost certification, hopefully there'll be some discussion and they'll reach agreement. But if there isn't, then we have to live with what the board says. And if the finding is that the profit has exceeded the levels, then this town of Scituate gets a check that they're not expecting. In the far more likely event that it doesn't exceed the level, then we all go along our merry way.
Okay. Can I just, and just again clarify, because these things get rather complicated. There are different monitoring duties with respect to a 40B, correct?
Correct.
So the construction compliance monitoring goes with the building code, a building commissioner, zoning enforcement officer?
Correct.
Okay, we're not talking about that.
No, we're talking about the money issues, the profitability, the profit earned on the project.
Okay, and then there's an affordability monitoring agent.
That is the monitoring agent that will determine whether or not the buyers of the affordable units are in fact qualified under the appropriate regulations, which do affect those sales.
And that's already been agreed to be Omega Ventures?
Well, you know, I got a call from the gentleman who owns Omega Ventures. His name is Avi Glazer.
Yes.
He is the individual who will be the affordable monitoring agent, but he has decided that he's not going to use Omega Ventures, which is his company, to do it. And
That's his company?
Omega Ventures.
Oh, I thought he was from Omega Ventures.
He is Omega Ventures. It's his company.
Yes.
And what he told me on the telephone the other day is he's going to use a different entity, but he can't tell me the name of it until later this week.
Okay.
So what I would suggest is that we modify my request, and hopefully the board's vote, to label Avi Glazer as the monitoring agent, Avi Glazer, or an entity, controlled by him to be the affordability monitoring agent.
Okay.
And SEB LLC is in fact going to conduct the lottery and do the marketing preparatory to the lottery. And if you agree that they are the lottery agent within the coming weeks, they will submit to you the marketing plan and marketing information as required by the comprehensive permit.
Okay. And so, and then what's left is the limited dividend monitoring agent.
That's what I'm suggesting should be the town of Scituate, acting by this board.
Okay. And I did also speak with town council on that. And I don't disagree with your sort of assessment of that. The only thing that I think we need to put in there is, or its designee or agent, because nobody sitting up here is going to be pulling out.
No, I agree with that, and I thought about it after you pointed out to me that we had not signed these various agreements which are attached to the regulatory agreement. The monitoring agreement, I think, needs to be tinkered with a little bit to say that you are going to get reimbursed for your full cost of your consultant, and that, it's, the monitoring is being done on behalf of the board by your selected agent.
Okay, but what I'm saying is I'd like to see that, because you're asking us to modify the regulatory agreement, correct?
No.
Okay, what are you asking us to modify, the comprehensive permit?
I'm asking you to modify the decision you made last October,
Which is?
in which you designated Mass Housing as the monitoring agent, rather than the previous town of Scituate acting by the Board of Appeals.
Okay, so, but what did?
We're just going back to what it used to be.
Right, but what did we modify last October? The comprehensive permit or the regulatory agreement?
The comprehensive permit.
Okay,
The regulatory agreement has not been tinkered with at all.
okay. Well, and this is kind of, this is actually, as I see this, is not probably, the comprehensive permit's probably not very, we've got a little bit of an issue on page 3, section 9. It's kind of, it would assume,
Scituate Housing Authority, way back when, was going to do it, but then opted out.
but they're obligated to do all the various types of affordability.
Yeah, and-
Everything. And so that whole thing seems to me, we need to, if we're modifying it, we need to clarify all of those different roles by different people.
Well, but I think the Avi Glazer, in fact, is going to do all of these. Although the marketing materials are going to be prepared by SEB and submitted to the board, as the affordability monitoring agent, Avi Glazer, of necessity, has to review all of these materials as
Okay.
required by the code, by the permit.
So you're telling me that in paragraph 9, page 3 of the comprehensive permit, we're looking at dated 2003, it says Scituate Housing Authority, through its director, will act as monitoring agent for the project. And I thought that's the paragraph you wanted to modify at this point.
The language, the nomenclature has changed somewhat. Back in 2003, what was identified as a monitoring agent is now the affordability monitoring agent,
Okay.
okay?
So is it the same title with a different name?
Sarah,
Same job, different title.
Mike,
address that?
yeah,
And I read through this, and I'd have to say I was really fascinated by this regulatory. And then I went on to read the other two that I hadn't read. But on page 10, it basically addresses conflict. It says,
well, we're not looking at that, wait, Neil,
no,
because I
this
just
is on
said,
the regulatory agreement.
right,
So in the event of a conflict or inconsistency, including without restrictions, more restrictive terms between the terms of the comprehensive permit, any other document relating to the project, the terms of this agreement, the terms of this agreement shall control.
okay.
So in a sense, I think we're probably covered.
In that agreement was, if you remember, reviewed by Mr. Toomey
Correct,
and approved by him.
correct. So where does that get us then?
I think it gets us back to asking you to vote on what I've asked you to vote on.
Okay, well, this is my problem. Let me just tell you my problem. You're asking us to amend amend the comprehensive permit, paragraph 9.
We've
Yes.
already amended it
Right,
in October.
but what I'm saying is, the only thing that amends, seems to me, or addresses, is the affordability
Correct.
aspect.
I'm-
So,
but-
and we're not talking
but
about the
in-
affordability.
In your November decision, you named Mass Housing as the monitoring agent,
Correct.
which is not the affordability monitoring agent. It is the one that determines whether or not the limited dividend requirement has been complied with. The regulatory agreement, which was signed by this board,
I'm sorry, go back, say that one more time. I'm a little slow sometimes.
and sometimes I am too.
I'm just trying to follow it.
The regulatory agreement
Yes.
identifies the town of Scituate acting by the Board of Appeals as the limited dividend monitoring agent, also called the monitoring agent.
Yes,
Function is to assure compliance with the limited dividend requirement.
correct.
Mechanically, it's done by the board hiring an accountant or other financial consultant to review the cost certification that my client will submit to the board at the conclusion of the project. If your consultant finds that the limited dividend requirements have been complied with, then it's all over with. If he finds some discrepancies, then we need to get together and resolve the discrepancies. Ultimately, if the client has made more than 20%, he has to write the town of Scituate a check. The far more likely event is there'll be no check.
Is this item number 10 in the original comprehensive permit? The New England Fund cost certification shall be done in accordance with?
Correct.
That's also a
That's the-
component in this.
That's the monitoring agent.
That's the monitoring agent. So we have the regulatory agent, or the monitoring agent above is going to be...
The monitoring agent above is, in fact, the affordability monitoring agent.
agent. So there's a terminology that's not clear. Or
Correct.
it's changed since 2003.
Correct.
The interesting thing about this, when I looked at the back of it, is this was originally signed in 2003, and it wasn't recorded with the town clerk until 2013.
Because
This has been going on forever.
The litigation was
I
going
understand.
on,
I
and we couldn't
recall.
record it.
I recall, but it's 2001 to 2013. Thank you.
There were various times during this process that I actually felt sorry for Richie Walden.
I can appreciate that. But I agree with what you're trying to accomplish. I think it's really just a housekeeping issue because of what's happened since this
Right,
came out.
but if we're editing number 9, Scituate Housing Authority didn't want anything.
No, they're not. They're gone. They're out of it.
Already canceled them.
Okay.
By the-
So don't you want to, so you don't want to put Scituate in there? I thought you wanted to put Avi Glazer.
I want Avi Glazer to be the affordability monitoring agent. I want the Board of Appeals, on behalf of the town of Scituate, to be the monitoring agent, and I want SEB to be the lottery agent.
Okay.
And that's what
I understand that, but I guess my problem is, that's not what number 9 says. Number 9 only addresses the affordability monitoring agent.
Correct, and 10 is the monitoring agent.
So you're asking for 9 and 10. I didn't see
Right.
that in your thing,
Right.
I'm sorry.
I didn't enumerate the paragraphs in the comprehensive permit.
Okay,
Because you're really looking not to modify the comprehensive permit, but to modify
Just
our
change
modification.
the players.
Because our modification in October already changed the players once.
Correct.
We're looking to
Update the change in players.
update the change of players.
Correct.
the players, however, are not, in number
Right.
10, are not described who that is.
We only changed 9, we didn't change 10.
All right, so
All right,
that's what I'm
so
saying.
that's-
Do we want to change it? 10, you want to say the ZB in-state, and number 10, you want to say is determined by the monitoring, the
Monitoring
limited dividend
monitoring agent, which is you, which I want.
or our designee.
Yeah.
Town of Scituate by its ZBA or its designee.
Correct. Or its agent, because
Or its
it
agent,
really
that's
has to be an agent, somebody
All right.
selected by you.
Or its designated agent.
I like that.
Or its agent's designated agent.
This will not be the building.
Which will number, or its designated agent. Okay,
Or assigns and heirs.
all right.
Appointed designated agents.
All right, so as long as we're really clear, and I guess that maybe be just me, then I'm really clear. So the 2 changes you're looking for are to put Avi Glazer at number 9, so that'll read Avi Glazer, or how, what did you,
That would be the,
He is the affordability monitoring agent.
right, no, but you had another term for his company. You get rid of,
or,
Or an entity controlled by him.
Avi Glazer or his entity.
Right.
DBA as he will.
okay. Will act as affordability monitoring agent.
Right.
Okay. And then in number 10,
Scituate Zoning Board of Appeals on behalf of the town or its designated agent.
okay, all right. Well, that seems no problem.
And I want to
To me.
include in a motion that SEB be designated to conduct the actual affordable lottery for the affordable units.
Okay, so where do you want to add that?
That's nowhere in here.
I know, well, we can add that.
Yeah.
How about,
Well, but, you know, if you want, I'll write the decision for you, as I have in the past.
Sure.
But I simply need, I think a vote to identify these 3 players as the new players, and I can put the lottery agent designation in as part of 9.
I think that'd be good, like an
which I
E,
think
subpart E.
where it belongs.
Yes.
okay, so I guess the first thing, is there anything else tonight? Okay, the first thing is we have to determine if that is a substantial change.
Move that the proposed amendment is not a substantial change to the permit.
Second.
All in favor? Aye.
Aye.
Okay,
Very good. I will send the draft decision in Word format to Nicole, and if you have any questions or comments, somebody give me a call and we'll straighten them out.
okay, great,
All right? Thank you very much.
thank you.
How are the sidewalks?
Are they up yet?
Are they plowed?
It will be done.
Good, good, good. Oh, Lordy.
Did the fall, winter months go more smoothly, or?
Come on, I'm cold, I'm cold.
Put your feet out.
Oh, all righty.
That was tough.
Well, these desks were built by the OTEC years and years ago. That's what it was, it was a OTEC project,
Nice job.
3 years something. At least that's my recollection.
Is a request for clarification from zoning board of appeals with regard to comprehensive permit issued on January 2003 to stop those 2 railroad tracks located at 90 Stock Road, Mass. 054 block.
Hi,
Good evening.
My name is Attorney Robert Galvin. I represent Stockbridge 2 Realty Trust and the people that are involved in developing this amended project. This one actually started before the last one, but we're not quite as far along as they are. I'll try to explain where I think we're at, and just some issues that I think that the board could help us clarify so that we can move to the next step. As the board will recall, or I guess there's a couple of you that were probably here when I was last in to amend this project. The last amendment was approved about 1.5 years ago, and it changed the project, which was then partially ownership and rental units, to all rental units. And there's a grand total now of 74 units with 148 bedrooms that are going to basically connect to a package treatment plant on site that will be disposing its wastewater via a groundwater discharge permit issued by the Department of Environmental Protection. Where we're at now is it took some time to create the actual construction plans. The construction plans were submitted late in 2013 through Mr. De Benedictis, who's seated to my left, to the board. The board engaged John Cheshire from Cheshire Consulting to review those plans, and some review letters issued. From my perspective, there's a little bit of a disconnect, and I'll try to articulate it as simply as I can. What appears to have been done is Mr. Cheshire wasn't really, or maybe he was, but he was basically given an assignment to review the plans and identify any issues in the plans. And the way the process works, from my perspective, and I sit on your side more often than I sit on this side, is basically a final set of plans usually come into the building department. If there are any unsatisfied conditions that require further review, and there were in this particular case, a consultant is engaged to review those issues and approve them, and once that's done, you're basically in line for a building permit, as long as you have a regulatory agreement and your, in this case, conservation easements are in place. We're not there yet with the regulatory agreement, because in order to enter the regulatory agreement, we have to have a final set of plans. So we're a little bit behind the Walden Woods project. So the review that came out from Mr. Cheshire indicated to us that he was looking at things beyond conditions that he probably should have been. John's not a bad guy. I know him well. He reviews plans for Norwell. I'm hoping tonight that maybe we can get some understanding between us and the board as to what remained to be done. There's one other thing that I wanted to bring to your attention. After the project was changed, there was a change in the amount of impervious surfaces in this project, and actually it was to reduce the impervious surfaces. When you take a spread out project in ownership duplex units and combine them in larger buildings, as we did in this particular case, you actually reduce the impervious surfaces. Not only did we do that, but we diminished the amount of roadway length. Some of the cul-de-sacs are shorter. A roadway was looped and actually saved space. There was a slight change to a stormwater system that's actually partially completed, and for which the Department of Environmental Protection has already given a partial certificate of completion. It involves a wetlands crossing, not on the Stockbridge Road side of the project, but on the opposite side of the project. In any event, it appears to me that I jumped in because it just didn't seem to be going in the right direction, and I wanted to see if the board and and my client could come to a consensus. The unfulfilled conditions that were still open for review centrally concerned the stormwater management system in this project. Just so the board is aware, there was a extensive dealing with the Department of Environmental Protection in this case. It went all the way up through an adjudicatory proceeding, and there was a final order of conditions issued that governs this project, okay, and has governed this project all the way along. But because of the changes that I explained to you, which are actually reduction in impervious surfaces, we had to file an amendment of that final order of conditions. And in January, the Department of Environmental Protection issued an amended final order of conditions. Their final order of conditions reviewed this project to determine its impact on all of the wetland protection interests that the department was charged with enforcing. It appears to me that there's independent review processes going on here now. Mr. Cheshire looked at this project. The Department of Environmental Protection looked at this project. The Department of Environmental Protection issued a amended decision, and I think that there were some questions, at least raised by Mr. Cheshire, as to whether the project complied with the stormwater management regulations. I would submit to you that the amended order of conditions is dispositive of that fact. I will share with you also that the town, via has filed an appeal of that amended order of conditions, which they have the right to do, on the changes to the project only. My understanding is there are some questions about groundwater because of a potential zoning change that's maybe coming up at a future town meeting here. The town has not mapped all of its water resource protection areas, and is, I guess, intent on adopting a new Zone A map, its first map in this area. You've always had a water protection district, and this project actually identified those areas, but you're changing that and adopting a new map. And it slightly affects this property. But this is a project that's already been permitted. And I've had a number of conversations with the conservation agent, and we'll sort that issue out. But right now, we have a review going on of the stormwater management regulations by Mr. Cheshire. We have a amended final order of conditions from the Department of Environmental Protection, which reviews the impact in the same respect. So, to me, it seems there's a little bit of a disconnect. So that's the central issue where the board reserved the right, and we agreed and didn't object to that, to look at this for compliance with stormwater management regulations. But we do have a final decision now from the Department of Environmental Protection. There are a couple of other things that Mr. Cheshire looked at, and I'm discussing them generally because I think that's the way to understand it best. And one was an area of general constructability. And I think he identified some things that actually Mr. De Benedictis has changed, but it wasn't something that probably shouldn't have been involved in. So, because that's not something that was reserved right to look at. The project has to comply now only with any unwaived local regulations, state regulations, and federal regulations. And probably the chief things that need to be done now with the state building code and things of that nature. Is that correct, Dick?
Right.
Okay. So I think there's been some discussion back and forth between Mr. De Benedictis and Mr. Cheshire. It was, as it related to me, I was told that maybe we needed to have this type of a meeting so that we were all on the same page. I just want to keep it moving because I can't get to the next stage, which is a regulatory agreement, without final plans, and the final plans have to be approved in order to move to that next stage.
Have the final plans been submitted now?
Yes.
And when were they submitted?
Well, there was a set of plans that were submitted as final plans, and I don't know which
It was
date?
August.
In August?
The original plans that Mr. Cheshire reviewed were submitted in August, actually at the end of July, the beginning of August. And then we waited until we heard from the DEP on our amended final order before we revised again, because we didn't want to be trying to hit a moving target here.
So
When
this
did
is
you
the
submit
second
those?
final plans.
Well,
now.
no,
The final-
now there's a third set
Yeah.
to respond to some comments from Mr. Cheshire.
Yeah, we actually, yeah, and as soon as we had that amended final order from the DEP in January, actually, then Mr. Cheshire and I talked, and we then went ahead and added the revisions that he requested onto the plan. So now we have a plan, which is sitting up there, that addresses all the issues. We believe it addresses all the issues that came up between Mr. Cheshire and anybody else that happened to comment in the last 3 months.
Okay, so those are the final plans.
That's the final.
Third final plans.
Yeah.
And when were they submitted?
Friday,
Friday, what day?
last Friday.
February 20th?
February 14th.
14th, yeah.
No, February 14th was a couple.
Last Friday.
February 21.
No, yeah, it was, yeah,
Correct,
21.
February 21st.
Okay, so, and tell me if I'm wrong, it's my understanding that Mr. Chesia then, he has to review those plans to make sure that they comply with the,
Stormwater.
no, I do more broadly, the comprehensive permit.
He's reviewing them, I think at Mr. Duggan's request, because it actually is supposed to be in the building commissioner's hands, for consistency of the final plans with the approved permit.
Correct.
And that's really what it is. So, you know, the original set of plans, this is a preliminary set of plans, these are the detailed building plans. And the issues that were outstanding, and I actually read it and read it again and highlighted it, it looked to me like, other than stormwater management regulations, all you were generally getting was the final building plans, which Mr. De Benedictis stamps with his stamp and says comply with state regs, local regs, and any unwaived local bylaws.
Okay. And there is a scope of services agreement for Mr. Chesia, correct?
I haven't.
Isn't that what controls what?
The scope of services, and then there's a contract from Mr.
Yeah,
Chesney.
isn't that
I don't
dictate
have-
what he's supposed to be doing?
Well, yes.
Okay.
However,
It's not-
my understanding is that he's actually also working for the Conservation Commission on this appeal as an expert for the,
And just, if I may, add,
Please.
we had a conversation when that, came to my attention, and we made it very, very clear, and mentioned it to the town administrator, that any expense incurred for the Conservation Commission would be billed directly to the Conservation Commission, paid for by the town.
Okay,
It is
so,
not- They will see no charges for any work done in
all
conjunction
right,
with
so
the
that,
Conservation
that's kind of two separate issues then, is that what I'm understanding? Conservation issues are separate from the
Well-
review of the final plans? Yes or no?
yeah, oh, they're two separate issues.
Okay,
But, you have a peer review consultant who's an objective evaluator for the board. Does this set of plans comply with the issued comprehensive permit? And then you have an advocacy role wherein he's acting as an expert witness for the Conservation Commission against the project. So that's not in my opinion, that's not something that should be happening. But, that's up for you to decide. We just want to move on and get
I
this
don't know
thing
how it's up for
done.
us to decide, we don't hire him for conservation, right? I mean,
Now, they're acting,
independently on that one.
yeah, they're on the list of, appellants allowed to appeal
Isn't it
superseding order, whatever you want to call it.
The repeal,
as much to your advantage, though, that the consultant has reviewed the plans?
well, I don't want to start all over again.
I know, I understand, but
I just want to kind of have an understanding that what are we looking at it? And I think we were looking at compliance with stormwater management regulations, but now we have a final order of conditions that he's appealing, and that the commission is appealing. There's something not right there, but,
But again, that's the commission's right to appeal it,
yeah, they do.
and we don't have any control on that jurisdiction there.
I'm not suggesting that you do.
And our scope of services with Mr. Chesia has been defined, and he's done his services for us. And I appreciate your client and his agent's architect putting together the modifications that were suggested, even though you've suggested that perhaps there was a little bit overreach, but that's great, we're all working together.
Right, and you know what, the changes that have been made are fine, we're not objecting to them, but I do want to see us get to the conclusion of this.
Well, we do too, actually. It would be great. So I guess I'm not really understanding where the disconnect here is, because it's my understanding, and if I'm wrong, please, correct me, or if Neil or Mr. Chesia or anyone else on the board, is that it comes before us again next when Mr. Chesia recommends to the board that we accept the final plans. and he's reviewed them and gone over them with you guys, and you've come to an agreement about what needs to be changed, or, and then we sort of, put the stamp on it.
Well, I guess what I'm suggesting to you, there is an amended final order of conditions issued by the state
Yes.
as to its this project's compliance and its final plan compliance with the state regulations.
So that, are you concerned that Mr. Chesia will not endorse the plan because of the appeal that's going on?
If he agreed that it complied, I guess there wouldn't be an appeal. I
Well, I
guess
don't
that's what I'm
know.
trying to
He
figure
could
out.
agree that it complied in the review and then appeal the issues before that the Conservation Commission has. They're two different areas of standing, aren't they?
They are, but I mean, typically, a peer review consultant isn't, litigating on the litigating side against you as well. They're truly objective. Look, I'm not looking to start over again, but I just really want to limit what's going forward here. We're not looking at all aspects of the plan. We're looking at, does this comply with the stormwater management regulations, and that's it.
If I could just share a little philosophy
I'd love to.
on Chapter 40Bs.
Please.
And it's, we're really getting impacted with 40Bs, and we've got more coming down the road. I think the legislative intent was to provide one-stop shopping in front of the Zoning Board of Appeals. When it comes to the permitting phase, and you correct me if I'm wrong, I think that's when the one-stop enforcement, the one-stop oversight, the one-stop assistance to the building inspector and to the town to make sure these water protection, water is protected, our water supply. It then becomes a responsibility, even in our, comprehensive permit, the ZBA shall tell us what, figure out how much surety is going to be needed. Board of Health is involved. So what happens is everything that is coming through is copied to these various departments in Town Hall. They are acting on their own. We're not getting together and say, oh, let's do this, let's do that. I think our conservation agent, who is passionately concerned with water supply, is looking at the report certainly, but not in any, there's no, like, we're not sitting down and saying, oh yeah, this is right. This gentleman's coming up with these conclusions on his own, and I think, with the support of the town administrator and all of us who are very concerned with the, if you look at the maps, there is a tributary to the water supply going right through that site. And I think, there's a legitimate concern for the water quality. And it's not just me, it's everybody in this town is concerned with, protecting the water supply. And that's how I see it. So we're all involved. Once we're, conservation may not have jurisdiction, but he certainly can, look at things. There's no law against that. Would you agree with that?
Well, what I don't agree is, there's a permit issued for this project, okay? And if groundwater impact was a problem, it was a problem from the beginning, and the intermittent streams have been there all the way along, and now they're being raised. That's where I have an issue, but I'll deal with that with the Conservation Commission. I just want to find out, what is entailed in the final review that goes forward from here. Obviously, he has to look at these plans, but really what he's limited to looking at now is, do the project plans as reviewed comply with the stormwater management regulations? Because that's the only thing that required a further sign-off.
Okay, Mr. Chesia, do you have, I'm sure you have comments.
Me? Sure.
Help us out.
First off, let me just run through what actually I did for the building department and the zoning board.
Okay.
I took the decision for the comprehensive permit and compared that against what was submitted in the plan. I think the first thing is that there may be some things that I raised that the board can address and say, yes, this is okay, this is not okay, this is what we were looking for. I was not involved when you ruled on this project, so I have to take and read the decision with a fresh set of eyes. Possible that I interpreted something different than you would, or different than what you had in mind, so I went through, and that's where my letter came through. I
I did not, wait a minute, I didn't, did we get a letter?
I did a letter back,
I don't know that I
November
don't,
18th.
okay, well, I will tell you that it's certainly not part of what I've got in front of me tonight.
Okay.
All his information is in the file that Neil has.
Okay.
Which letter are you referring to, John?
The original letter, the original review letter with the decision was dated November 18th, 2013.
Right.
Okay, so,
I'll
all
bring
right.
this up to you.
All
Well,
right.
it's a long letter.
I don't want it.
We've got a short one, too.
Yeah, I don't think we need to get into that, I just want to.
No, okay. So
Subsequent to that, I went over some issues with Neil, and I developed a memo dated January 7th, 2014. I don't know if you have that.
Nope.
Okay. We sort of condensed some of the comments
Okay.
to things that I think that maybe the board would want to provide some clarification on. I can sort of run through those if you'd like.
Well, let's just talk more generally first, and then we can get, whether or not we're going to get to the specifics, or is that something for another day, I don't know.
Well, I think that these specifics relate to exactly what Mr. Galvin's discussing.
Okay. All right.
Maybe more points than he's bringing up. He's basically bringing up stormwater. I have a few others that I think may be appropriate, and it would help us sort of get off the dime, shall we say.
Okay.
And move along. Because I don't have a answer whether some of these things are necessary, but I'm throwing them out there, and the board can then tell us that gets it off of my letter, or it gets it back into their court to provide the data.
Okay. I think I understand where you're going.
Okay?
All right.
All right. So if, Nicole, would it make sense to get copies of this?
I'll run, you can keep talking, I'll run.
Okay, because, you know, to me, you know, we're already at the final plans, the final plans submitted to 2013. Have you had a chance to review those?
No, I just got them. I mean,
Okay.
actually, I got an email that they were in Friday. I actually came here and they weren't yet in.
So isn't the issue possibly some of the stuff you're talking about maybe addressed in those final plans?
I looked at the issues relative to the memo before this meeting and didn't develop a new one, but I wrote some notes. And I think that you know, it's not gonna take too long. There's 1, 2, 3, 4. There's like nine items that I think would be worth discussing.
Okay.
We kind of try to get at that, and then I can, you know, elaborate.
And by getting off the dime, you're saying by getting to the point where you can recommend to the board that we approve the final plans?
Or at least have a direction in which to go, whether they need to do more work, or whether
Okay.
it's okay with the board the way it is.
Okay, so
I still need to look at the plans in, you know, more detail. I just
Okay.
sort of skimmed them for these particular issues. Because these issues are ones that I have questions on relative to the board's decision.
Okay, is everybody on
We're
point?
not going to be making a decision on the final plans tonight. We're just simply
There are no
trying to
final-
clarify some
I
of the
think we're trying to
concerns Mr.
decide
Galvin
whether
has.
he should look at all 9 issues, or just 2 of them, or
Right.
whatever they are.
We want to try to make sure that we're limiting the effort to a efficient
Yes,
review
I agree.
and
Okay.
move forward.
And some of them I think are fairly easy, they might be fairly straightforward, do you know what you asked for and what you wanted? And again, it wasn't necessarily clear to me, so, you know, maybe these can get, some of them checked off pretty easily. Some of them maybe will require a little more looking into it.
Okay,
The first one was the lighting. When there is information on lighting, they show the poles, they show the pole locations. Typically, when I hear a lighting plan, I think of a photogrammetric plan, what's the intensity of light? Because the decision typically relates to what's the intensity of light at the property limits. Are you having any light, you know, trespass onto neighboring properties? And there is no photogrammetric plan. There is a detail for a post and light, and there's a location for various lights within the plan. What was the board's pleasure relative to that decision? Did you want a photogrammetric plan, or you just care where the lights are and the light detail?
Well, I think, first of all, none of us were alive when this was permitted.
Sure we were.
I'll help you and tell you what condition it is.
Well,
if it'll-
I don't,
That's why, yes, condition 9, it says all lighting for the project shall be installed and maintained in such a way that the light shall be shielded and directed so as to avoid the direct emission of light onto nearby residential properties. No exterior lighting shall be located higher than the elevation of 20 feet from the ground level. A lighting plan shall be submitted to the building inspector for his approval prior to the issuance of a building permit. It would seem to me that that is very clear, that we're looking to limit light exposure to neighbors and elevation. And I recognize it's a challenge. It's something that it's probably an expensive proposition, but it was clearly part of the decision with the intention that you and I both signed it.
but, this is the modification of the comprehensive permit.
Right, but it's still that's the one that that's what we're talking
That's the one we're working
about.
off of?
Well, it hasn't changed. I mean, that's the one that, if it's the modification, that's the current one.
Okay, all right, all right. Well, I just didn't know, sometimes we only have those items that have been modified. This is the entire permit, though?
And Mr. Chessier's comment here is that the plans of lighting should be at a scale of 1 to 40, at a minimum, so that you,
The layout is at 1 to 40, but the question remains, do you want some
more-
sort of light intensity plan so you can demonstrate that in fact there is no...
so the question you're asking the board to consider is what's been presented to you sufficient to satisfy number 9 with respect to a
I
plan?
can't tell how far the light's going to shine from this.
And Mr. DeBenedetto has,
The requirements are not, Mr. Chesky just described, there's no requirement for photogrammetry. What we do is we have an 18-foot high pole, not 20 feet high. We have a shot, we have basically a shield over the lights. This is what's usually required. A shield over the lights so it doesn't spread, and these are lights on the street. This is a residential, it's not a parking lot for, I've got a lot of supermarkets, parking lots. That's usually what you're concerned about. But this meets all the requirements that are in that we just read. And this has been on here for, this wasn't just put on there. This has been there for the whole year.
Well, where are the lights in the regular plan? I mean, that's an individual light bulb.
He's looking for where the light poles are
The light
on the
poles,
site
yeah, the
plan.
light poles are on the actual plan. But I'm saying what Mr. Tibbetts just read, requirements are all met on this detail sheet.
the detail sheet's clearly indicating that no exterior lighting shall be higher than the 20-foot
And we
elevation.
have 18 feet, we have a shielded light.
So you've got shielded light at 18 feet and directed so as to avoid direct emission of light onto nearby residential properties.
Right. It's directed down, so it can't be.
Okay.
It's basically shielded. But the actual utility plan, which shows the lighting, we have, there were some comments by Mr. Chessier as far as the location lights, which we did revise and we complied with them. And basically, it's on this plan here. And there are light posts, and you'd have to be looking at it closely as, one of the things that Mr. Chessier wanted, we had originally a 1 inch equals 60, so it was more difficult to
You
see.
scaled it.
Yeah, so we brought it up to 40, which was his suggestion, which we agreed to. So you still have to look at it pretty closely to see where all the utilities are and the lights. But the lights posts are shown on this plan, and they're basically in front of the homes, just like you would have.
So the neighboring properties are shielded from the lights by the buildings.
They're not, yeah, I mean, the
To
only
some
thing we're going to
degree.
show is the street, basically. I mean, this
Are
is.
there any lights on the outside of the building? On the other side, or the back side of the buildings,
No,
if you were?
no.
So they're all between the building and the
These
street?
light posts are all on the street, along the street, which is where they should be. And they're all exactly the way it's prescribed in the regulation. There is no deviation, except it's 18 feet instead of 20 feet.
Where are the abutting residential properties?
The only abutting really is this
Housing
Miller
authority.
Park
Housing
up
authority.
here, which is above us, and that will also be shielded. There's a series of, there's a landscape plan here, which has a series of vegetation up there. It's higher than we are, and we would be shielding that generally. But the lighting, there's no way that the lighting from here can be over. I mean, you got buildings in between there. So what we've done is we've taken into consideration everything that was required, what's been asked for is something that wasn't required. In photogrammetry, to do, an electrical engineer does that for a shopping center. We've done a lot of them. You get the spread of the lights, because you get so many lights, and you basic, you're not trying to direct something in front of a home. In a parking lot, you're lighting up the whole parking lot. So you're not shielding it the same way you would in front of a home. So we believe we've met that requirement. And I've given Mr. Chesky a list of all the things that we changed.
Okay, but if I
Let him
can
go,
just
let him
stop
go
you.
through it, Dick.
Yeah.
Let him
You
go.
know,
Sorry, no, and I'll address him as he goes through.
yeah, Mr. Chesky, where is your concern on, because do you have some specific concerns, or it's just the fact that a light intensity plan has not been submitted?
Well, it's a question for the board. Certainly, from what he's showing, I can't tell what the light intensity is from those lights. I'm not an electrical guy, and I'm not a lighting specialist. There are lights on the entryway, too, that maybe are closer to some residences because that's a narrow strip, and I'm not sure what the spread is there. The board has a decision that says this is what we need, is that it doesn't have any light overlap. And from that plan, there's insufficient information for me to say that they've complied.
So you're concerned particularly on the entranceway?
You don't see the entranceway on that
I'm
plan.
not sure.
That's the entranceway, and you've got the
Frankly,
other houses there.
it's not like I have a real, these lights are 18 feet high, I don't know how powerful they are.
Right.
Do I have a concern that light overlaps? I just have a concern that it complies with the permit. The information presented does not allow me to tell you that it does.
Got it. Okay.
And of course, we contend, when you have a shielded light, that's the point. The purpose of the shielded light is not to have a spread. That's why you have a cap over it. It directs the.
Well, there are shields and there are
So
shields.
if I can see the light
You know?
from my house when
They're
this
not all the
project's
same.
done, you have a problem, right?
Right.
So if we could,
And then we have to deal with
lighting
it.
plan
All right.
shall be submitted to the building inspector for his approval prior to the issuance of any building permit. So I'll do it, be something I need to approve.
This is the intricate here.
I think,
You think you can
think it's
decide?
yeah, I think we're gonna make sure that the lights that are directly facing neighbors across on Stockbridge Road aren't going to be a nuisance. That's what we're gonna
Okay.
do.
So you're content with number 9?
I also want to point out, these are revised plans. Changes were made on this plan, per John's recommendations.
Right.
And John has not had a chance to do a thorough review of these plans yet. So they came in Friday, and I think, this
I wonder
is
why we're here.
John's.
Why are we going through this then?
Well, this is what I'd like not to happen, have a full review of the plans for something that's supposed to be done by the consulting engineer.
Right.
And I think, the next item on the stormwater review may be the most important, because I think as the comprehensive permit reads, it says they have to comply with current standards.
Right.
If this appeal, if it's dismissed or, and DEP says, no, you have to comply with the standards back then, I think the question, that's a moot point. But I think we have to see what the result of that appeal is before we can really address this. And as far as the review, I think that maybe another question that during the construction process, I think Mr. Chesky is also charged with kind of overseeing the construction, monitoring the construction, make sure it's being done properly.
Yeah.
So in conjunction with that, he is going to be looking at stormwater systems. And I think the suggestion, this is what I'm getting, that DEP is somehow going to come down and monitor it. I don't believe they do that. So I think the town does need, and I think is written in the comprehensive permit, that although DEP can say, that you only had to comply with standards back in 2001, we still need to monitor it, because DEP is not going to monitor it.
Right.
The actual original approval was 2007. But there was a process that we went through with the Conservation Commission, which we first were denied any access to the property by crossing the stream for about 2 years. And so we couldn't go in there to do any test pits. There were test pits done prior to our involvement, but then all of a sudden, they wouldn't let us cross these intermittent streams. So we got a denial for them because they wanted us to do the stormwater system. They wanted us to do test pits right where the stormwater systems were, but they wouldn't let us take any equipment to there. They said, go across the MBTA property, which was under construction. We couldn't do that. So we were just being held back. So we got denied. We went to the DEP. We got a superseding order of condition after they reviewed the plan subject to all the Wetlands Act, which is a state law, okay? And that's what you have to comply with on the comprehensive permits, it's the state law. The Wetlands Act is state, it's not local. So we got the superseding order of conditions. That was appealed by the Conservation Commission. We went back again and went for what we call a final order of conditions. The final order of conditions came to an adjudicatory hearing where we all went to Boston, to a DEP office of DEP. And basically, as a result of that, the DEP officials said, they basically agreed with us, and they advised the town, the Conservation Commission, to work with us to come up with a settlement. They came up with a settlement at that time that agreed to do certain things as far as the groundwater, I mean as far as the stormwater management system was concerned. As a result of that settlement, there's a signed agreement saying a final order of conditions was resulting from a settlement, and that the Conservation Commission, actually the town, waives all rights of appeal to court and adjudicatory hearings. It says it in the final order of conditions. It's right there. Nothing can be appealed having to do with that stormwater plan, okay? Now, when we went for an adjustment on that, called an amended order of conditions this past year, it was because they changed it from condominiums to apartments, and so you have to show how that affects. We also shortened a road, and we eliminated a parking lot, so we had to do an amended order. The amended order only addresses changes to the stormwater system, what is flowing into the system. So we showed the HydroCAD calculations, which showed that it was actually a reduction. There's a reduction in flow going to all the stormwater systems that were previously approved. There was only one change. It was a minor change of a pipe. Instead of going to one basin, it went to another basin. It's this one right here. It's up here. It goes to this basin now instead of that basin. That was the only change. So DEP took about 3 months to review that. And then they issued an amended order, final order of conditions on January 23rd. And it stipulates in the regulations, and it's section, I believe, 84 or 85 of the Wetlands Act, it stipulates that you can only appeal the issues that were changed. You can't go back and appeal the amended file, which you already settled and you already signed off on. You can only appeal the changes. That was the only change. What's being brought up now by Mr. Chessier and the Conservation Commission is, hey, we want to look at this whole stormwater system again. Well, that would be nice, except that was already taken care of 3 times by the authorities. This board is not the authority. Conservation Commission doesn't have the capabilities of reviewing that. The authority is the DEP. They made decisions 3 times on that. They made it superseding, they made it final, and then they made it amended final. So how can you argue with the DEP's regulations? That's what's been approved. That's what Mr. Galvin is saying. We have a permit. The permit is rigid. You can't go back and look at it again. It's already there. It says right in the final order, no appeals. You can appeal on any changes. What the appeal that came out of the Conservation Commission this time was because they're proposing a zoning change that would make what they call Zone A. And in their appeal, they say, we do not represent their Zone A. Well, the Zone A isn't even on the warrant article yet. I got a paper from the Sabo that's proposed for the warrant article. It'll come up. Zone A basically is a water resource protection district. And actually, you'll see a map out the hall that says an amendment to the water resource protection district. In their appeal, they're saying we didn't show that, Zone A. No, what we showed is the water resource protection district, which is the way it is today. Okay? Now, what the Zone A does is it takes a little piece here, and the only difference between what we had is that they have a piece here on this little intermittent stream that they'll put a 200-foot barrier on each side. We're not under that jurisdiction yet, and it hasn't even been approved yet. It's got to go to town meeting, and it also has to be approved by DEP. So we did comply. Everything going this way is under Water Resources Protection District. We basically, instead of having 20 or 30 septic systems out here, which also the appeal says we have septic systems, we don't have any septic systems. What we have is a wastewater treatment plant that has another standard, another state standard called groundwater discharge permit. which is a whole separate regulation from Title V. Title V, if you have septics, we are dealing with, there's the treatment plant in its stream. This is what, all the, 99% of this is underground except for these two little spots here. But this is the treatment system going to a leaching field. This is a park, basically. It's all open space. This will all be underground. So we put a wastewater treatment system which had to meet very high standards, which had to go through the groundwater discharge permit process, which is a very expensive process, a lengthy process. Instead of putting septic systems all the way around, which another developer might have tried to do. But we looked at this water resource protection district, which is, this, and we now have a proposed limited wastewater treatment plant that the quality of water just coming out of this pipe would be less, will have less impact than one house would have had in septic systems. This is going to handle all of these. Basically, we have nitrates at 10 or less. We have BOD at 30.
Dick, can I interrupt you for a minute?
Sure.
They're not going to be able to adjudicate this. And I know they're probably interested, but I don't think they need every detail on this one. So
Yeah,
I don't want to stop you, but they
I know
want to
he's
know
gonna-
whether the permit requires it or not, and I think that's what you want.
Yeah, I mean, I want to know, I'd like to hear from Mr. Chessie. I mean, you're giving great detail, but I don't know that I need the detail. What's your issue?
Okay. My issue is that your decision says that the plans need to comply with storm water management regulations, which is a very specific set of conditions.
Okay.
That are required. The project was submitted many, many years ago. The regulations have come out since that time. But your decision says the regulations. Now, what Mr. De Benedictis is saying is that the old decision required that they comply with stormwater management policy. I think you would need to amend your decision to say, if in fact that's what you want to do, or if that's what you meant, to say, comply with the policy. Now, I'll go a little further on that, but your decision says stormwater management regulations. There are very specific things, there's a booklet, handbooks, that goes right through, that's what you're supposed to do. Policy was prior to that, and in effect at the time of the submittal, and it's less stringent and has less stringent requirements. There are still requirements. DEP, in their decision, said, and it's actually in their decision, that says that the plans must comply with stormwater management policy. Doesn't say that they do, it says that they must.
Okay. That doesn't seem all that complicated to me.
It isn't that complicated, but the regulations are different than the policy, and there's some things that are fairly significant in the change in the regulations and the updates in the regulations.
Well,
This is why the detail is important, because DP just looked at these. DP is the regulatory authority for stormwater. You can't go back and say, hey, DP didn't know what they were doing when they just reviewed this in the last few months.
I don't know that we're on different pages. It seems to me, I'm not any kind of an expert in that, you know, and if DEP says this is what they need to do, I'd be content with that. What's the, and so is it a matter of verbiage in the?
I think that your decision, if this is what your intention is, then your decision should say compliance with DEP's stormwater management policy, not regulations, because they have very specific meaning.
For me, I would like to have a clear understanding, and I don't think it's going to happen tonight.
Yeah.
But it sounds to me like what the applicant is looking for and what to comply with DEP's decision is that we probably reduce the strict regulation that we've cited. We've cited regulation as opposed to policy. DEP cited policy, and the applicant is proposing that policy is what we should hold to.
And you're very rightly, if it's not according to reg, you're very right to bring it up.
But,
You know?
but we would have to make a decision that regulation is not what we intended. And if the DEP may have looked at the plans, they may have looked at the whole thing, they may not have picked up on that. And But I'm not a judge here. I'm not adjudicating the issue. But if we're not willing to change it, then DEP's decision doesn't meet
It is in
our
the
decision.
whether it was policy was in effect a regulation. You had to comply with that. And it wasn't that long ago, as I said, we went over the last 5 or 6 years, 3 times back to DEP. So we had a current situation. The policy, the items that Mr. Chesky is citing as we're not complying with are not items that are really of concern on this particular site. And I'd have to go into detail like the fact that we have a 2-minute perk out here, but we designed the basins at 40 minutes per inch, so it's really conservative. 2 minutes to 40, basically a whole different ballgame. We are being super conservative on our designs of the basin, and that's why.
I'm not questioning that, but it sounds like in order to be able to wrap this up, we'll have to make a decision that the verbiage in our already recorded decision needs to be modified, and we can make a decision whether that's substantial or insubstantial. But we can do that once I know better what the issues that are at hand within it and what we're giving up by doing that. We're giving up little, as you say, that you built a very, it was permitted to comply with the regulations.
It's permitted to comply with the Wetlands Law Act. There was nothing above that in a town, any town.
All right.
Wetlands Act
Again,
supersedes it all.
Again, that's, for me to be able to modify our decisions terminology, I need to be comfortable that the two come into sync. And if there's any give on the part of the board, that I know what I'm giving. And I'm not suggesting it's hard to do. I'm simply saying I need to know what that is.
Can I make just a quick suggestion? The changes that were made to the project were not to change the stormwater design of the project.
That's understood, but they do change, the changes that were made to the project do change some of the components, for example, the roadway layout, et cetera.
Yeah, but it reduces the impervious.
I don't disagree with that.
Right. And, I mean, I cited, and the board cited the final order conditions from DEP, and the changes that we were making were not to stormwater design. So, I mean, I think it's pretty clear, you know, that it was intended to comply with the final order conditions that was already had. And obviously, we knew we had to go back and amend it because there was a change in the nature of the type of housing, and you had to demonstrate that it wasn't going to have a greater impact than what you had before.
Okay, Mr. Chesky?
Just a couple of things. So that's something that the board needs to think about. As well as in the decision, so there's a couple more things, just from my perspective, relative to moving forward. So if you can decide many different things, but if you decide that it's the policy, then
As opposed to regulation.
Yes, then you can either accept DEP's decision or whatever, or you can say, does it comply with the policy, and ask me to look at it. That's a decision. I'm just throwing that out there as something that's still in your purview.
Are these two different things that we can look at, the policy and the regulations? I'm having a hard time.
My review is related to the regulations. The difference in the regulations versus the policy is that the regulations, well, the policy, first of all, is a policy. So it didn't have the same teeth.
Right.
The regulations are a regulation. You have to comply. That's the law. Whereas the policy was a little bit more wishy-washy.
But you're not saying that or nobody's saying that the DEP is suggesting, when it said you have to comply with policy, that DEP was saying you don't have to comply with regulations.
Yeah, they did. Yeah, the regulations, they changed the regulation. When they went from policy to regulations, they changed. There were 9 standards under the policy, there's 10 under the regulations, and within those standards, they raised the bar. There's certain requirements that are more stringent. Separation from groundwater is more stringent. TSS removal, it's more detailed and more stringent.
In policy or in regulations?
Regulations.
In the current regulations?
In the regulations, yes.
Okay.
So, erosion, there's a bunch of things that they changed that they made more stringent, higher standard, and they gave, the policy was something about like this, including all the details and stuff. Now, there's like 3 handbooks, there's way more details, there's a lot more guidance as to how to do these things. So,
When did that shift take place? That it went from policy to regulations?
I think that the regulations are maybe 2008, and the policy was 96.
So after 2008 is when it went
The
to...
regulations have been in effect for a fair number of years now. But just a couple other things. Within the current DEP decision, it is unclear to me how they can have final plans when they are still required to do testing in the stormwater basins under the DEP decision. Because as was stated, they couldn't get out there. Now that the culverts are there, now they can. And I would like the board, if that does need to be done, I would like the board to authorize witnessing by someone from the town. It'd be nice to see what the water table is, especially this time of year.
Is that part of the peer review, or is that part of the conservation appeal?
That's in the, well, it could be part of your decision if you accept the policy. It's in their DEP decision. You could just mimic it to have that done.
Well, yeah, and again, when they submitted this stuff to DEP for their review, did they submit very specific plans?
Yeah, I think they submitted, though, the plans the same as were submitted to the ZBA, not these current plans.
And did DEP approve those plans?
They did, and that's one of the conditions was to do the soil testing.
Okay, well, so nothing, well, because presumably there may be some changes required depending on the outcome of the soil test.
Exactly.
Well, how can, yeah, it seems to me that you can't approve.
Can't approve the plans till that's done anyway.
Right. So we have an issue there, but.
Yeah.
These are 99 test pits that were done prior to our being involved. I did an additional 4 on site. Out of these 99, there's about 75 that are less than 2 minutes per inch. The highest one is 10 minutes per inch. As an engineer, you have to use some logic on the site when you're not allowed to do we had to submit a plan in order to get a denial, okay? But as we look at it, and these are all the test pits. These are all test pits. The fact that this test pit isn't exactly in the basin over here, and this test pit isn't exactly in the basin, it's on the edge of it, and the fact that you have water information, there's at least 3 ways to find out where groundwater is, okay, in the regulations, and you do this, whether you're doing Title V, whether you're doing hazardous waste work near a swamp or whatever. It's either you're doing it by observation, you can do it by test pits, you can do it by maps, okay? So we had to use the 99 test pits and the fact that we had less than 2 minutes per inch because the issue that Mr. Jessica is bringing up, well, how do you know what the perk test is there? Well, we designed it at 40 minutes per inch. There isn't anything near 40. I'm sure some people...
Is that what the DEP is saying they need to test?
That's not
Perk?
my question at all.
Yeah, I didn't think so.
The soil's pretty good out there. I think it's gravel now.
It's just
My
gravel.
question is, I did review all of his test pits, and I looked at the locations, and when I look at the recharge basins, they have to be above groundwater by a certain amount. Usually the edge of the wetland is a pretty good indication of where that water table might be. And I do have some concerns that some of them may be close to the water table, and that's what the testing will prove. It will prove too if this happens to be, sometimes when you get close to the wetlands, the soils do change. But most of those tests, there's 99, as he said, originally they were going to do septic systems, so they did a lot of septic system tests, not necessarily the stormwater tests. I'm not arguing with the rate of infiltration as much as I'm concerned about the water table at the location of the basin. Because if they're full of water, they're not going to infiltrate.
But you do say that it's not, and there's a difference between a retaining basin and a detaining basin. A retaining basin is basically everything's filtering into the ground.
You know, we just keep getting a little afield of where we're headed. If we could just kind of stick on, as I understand, there are 2 test pits that DEP said need to be done?
I think what they said is that he needs to test at the location of the basins that are on, there's one that's been built and then the other ones haven't been tested because they were past the stream.
Is there an issue with that, Mr. Gowan? Why that can't be done, or is not going to be done, or
Well, I
are you
mean,
going to do it, or?
Well, we have to do it to comply with the state order.
Right.
So it seems to me that the state is protecting the Wetlands Protection Act, and so is the town.
Well, he's just simply, he's been
We're not
asked to
asking you to
make
do it
sure.
twice.
Yeah, he's just saying that,
But there's not gonna be any final sign-off on any plans until, I mean, we're in a chicken and an egg scenario here.
You're saying in order to get your final plans, you want to know whether you want to do these afterwards or before?
Yeah, well, the state has authorized them to be done
I have a
afterwards.
suggestion.
please.
While we're in this process, John has been hired to monitor construction, okay?
Okay.
By the town.
No issues with that either.
Any authorized activity that is going to be done out there from this day forth needs to come to me. Tell me what you're gonna do, tell me when you're going out, and I will send John out there to monitor these test pits, period.
I mean, it
We're
seems.
complete within our rights to do that.
Right.
And they're going to be done, the test pits have to be done anyway at some point in the.
Right.
But
in the
I
project.
was
You're
suggesting they be
saying-
done after the final plans.
Yeah, you wouldn't do them after the final plans because it could affect the final.
So when can they be done?
Something you do first.
Is this
You don't
holding
do-
us up?
You don't design a septic system.
We have a
without
chicken and an
anything,
egg
you definitely
scenario
first.
here. We're never gonna get anywhere.
We're still ignoring what I tried to say because you didn't want to hear it, but.
No, it's just that I don't mean to be disrespectful, but I feel that I'm getting more information, detailed information from you that just has no context for me. You know, it just is not sinking
I
in.
tend to react when somebody gives me a contradictory statement. We do that with engineers, you know, get 10 engineers.
I think the board, Joe, you just want to hear where those
Well, we
9
need to-
areas are and how we
Yeah.
resolve them. I think the
Yeah.
lighting plan, that'll go to Neil. It's actually not required at this stage, it's required before building permit issues. I'm completely satisfied on behalf of my clients that Neil will do the right thing prior to the building permit, so.
And I think we're trying to work through this issue.
I know you are.
Policy versus regulations.
No, and we're not going to litigate the conservation appeal with you
We
either,
know,
so.
please not.
So, I mean, I agree. I want to get to the other 7 issues, so.
So, I mean, because I'm kind of.
I do now for the first time understand why John is saying what he's saying.
Okay,
I
good.
did not understand that until I heard it tonight.
Okay,
We've had some good movement forward then.
that's right.
That's good.
So
I mean,
And we're not saying we can't come to terms with policy versus regulations. I think what I'm hearing from Ed is particularly is that,
I mean,
is this something we
want
want to give in on or not?
I don't want to waste a lot of time, you know, arguing about what was intended, but this wasn't intended to change the stormwater design at all. And I see what it says, and I see why John's saying what he's saying now. You know, it wasn't intended to subvert the existing final adjudicated case.
Yeah.
I think everybody probably would understand that. And maybe that's the way it's being viewed now. So I would like to clarify that and resolve that with you.
So
But I'm
that's
not
kind
sure
of, so
that,
far, that's the big issue that I'm not sure we can get to tonight, but maybe, yeah, maybe we kind of need to move on, and then we're
I'd
going to have
like
to
to hear the
visit
other
that
ones, yeah.
again. All right, Mr. Chesia, number
the
22?
next one is, and it's really a question for the board. It says that you have a 24-foot pavement, and sometimes the pavement is interpreted as the traveled way. In this case, 24 feet is the traveled way plus the berms. And I just want to make sure that's what you meant when you said 24 feet of pavement.
Now, is the berm, what is the berm made out of?
Pavement, it's, you know, you got the
It's
road, and then you
It's
got
Cape Cod berm.
the berms, 1 foot.
Yes, a
berm each
little,
side.
okay, so it's still kind of asphalt, a little,
Asphalt.
to deflect the water
Right,
onto the
right.
pavement, and
But the terminology in the decision is that it's a 24-foot paved way. Was John suggesting, are the berms outside that paved way, or do
What
they
was
take
the
up
is
the
intention
it,
of
paved way?
is it 22 feet with 2 1-foot berms?
Or is it 24 feet with 2 1-foot berms?
This is by the way, this is a driveway. It's not a public way. This
is it a
is
driveway for
this project only.
If I could add something, I think John and I sat down for 2 hours, and we went through his report, and we tried to winnow out the important things.
Right.
And the things that needed just a determination by the board that may have been a little ambiguous, you know, in the hopes of moving this thing along. And
Right.
that's one where I said, you know, yeah, the board, I think I know how the board's going to go on this one. I think it's fairly straightforward. I would recommend that it's okay,
yeah,
and we can move along.
I agree.
Okay.
But what John's doing, his charge is to make sure that the plans that he's looking at are consistent with the plan, and not to go backwards, but that the comprehensive permit clearly says regulation. John
Right.
needs to know whether he should be reviewing for regulation or policy, and that's,
Okay.
you know, a legitimate.
Well, maybe we'll get it down to that one issue.
Yeah, I think some of the other ones, I think, the new plans do, so number 24. The new
Oh, no, wait,
plans-
let's go to 22. What, I mean,
Well,
let's,
that was
what,
22 was the roadway.
I know, the roadway.
I
what
would,
it-
I would suggest a
Paved
24-foot
recommendation,
paved roadway. It is ambiguous perhaps, but a 22-foot way
lane.
with 1-foot berms is a 20, in my mind, would be a 24-foot
You
paved
agree
way.
with that?
I wasn't here at the time, so I don't know.
No, I wouldn't hear either, but we gotta, you know, we're still
Yeah.
charged with figuring it out. So you have any problem with that?
No.
Okay.
Okay.
All right, so I think we can do that. 22-foot roadway, 1-foot,
Well,
berm each side.
Bottom line is the plan complies.
The
Right.
plan would-
If we interpret it that way, the plan
Yeah, yeah.
complies.
Again, I haven't looked at it in detail and I haven't put a scale, but I think that was the intention.
Right.
Um,
You're just looking for clarification of what was intended.
Yeah, I
Right.
believe number 24 talks about the water main, which was not on the plans before. It's on the plans. I do believe that DPW needs to actually look at that and say it's okay before I say it's okay.
okay. I would comply with that, absolutely.
So I'm not going to say it's okay until they look at it.
Okay.
28 talked about phasing, and I'm not sure if this, that might have been carryover from the prior project, but I'm not sure on the phasing of this, if there's 2 phases or not, it wasn't really clear.
I believe we still intended it to be 2 phases.
Yes.
And so therefore the phasing, but I don't know that it has to show particularly on the plan. It's clear with Neil.
When you
that
say phasing, do you mean infrastructure, then
It
building,
says,
or do you mean?
it says specifically, 28 says, "The entire project shall be constructed in 2 phases. In each phase, all infrastructure, utility, roads, drainage, et cetera, to the service areas, properties shall be constructed as shown on the final development plans prior to the construction of any building in that phase, with the exception of," so it does have to be
You
delineated.
have to show a line somewhere that says this is phase 1, this is phase 2. like that.
Either a line or a narrative that indicates that
Okay.
these units would be part of phase
Units
1,
1
these
through
units would be
6,
part
and
of
then-
phase 2.
Right, there is such a plan, it's called sequence of construction. It's within the SWPPP, which is the Stormwater Pollution Prevention Plan, which talks about erosion and.
As long as it's provided so that it can be understood by Neil, because Neil's going to be reviewing
One of
that.
the issues we have here, and John and I have discussed this, is that we have, right here is a very large hill, and it's mostly gravel, and that has to be taken down before anything can be done. And we don't want to be taking it off-site, that's part of what we want to grade the site. So it makes the phasing a little bit tough at the beginning. In other words, it's almost like, okay, we got to take down the hill and grade the site, and as we do that, we got to do erosion control.
I know when we reviewed, when we've reviewed these in the past, and I was here when this started, the phasing, we don't want to be in the business of telling you how to build a project. We just want to be in a business of saying, don't take this project, make a huge, nuclear waste site, and then go out of business and leave us with nothing. We want to see it advance in a way that can be completed or be picked up by another if such things happen to happen. We don't wish that to happen, but, so you need to tell us what the phasing would be, and it needs to be clear.
And then in addition to that, part of the phasing where the grading site is a phasing on the development of the actual buildings.
Okay, so are you good with that, Mr. Chessier?
So that's fine, I haven't really seen that.
Right, but at least
That's
we
clear.
know where we're going.
See now.
Right,
Just want to make sure it's still in there.
okay.
The next one, again, is, they did, on the latest plans, show some of this. I'm not clear what was meant by it, and this is number 32.
Okay.
And it says, it regards easements in conservation areas. And it requires that certain areas be protected from development by a conservation easement. So there's, I don't know what the board's intention was. Was the intention to protect all of the wetlands? Was it to protect the stream? Was it to protect only the retention basins? Because it talks about basins and whatever in the actual decision. So I just didn't really know what was required, but the plans initially didn't have any easements on them or protection easements at all. The current plans, I believe, have a conservation easement around the basins themselves, but what was the intent of that?
I think it was boilerplate, to be quite
That's not
honest.
good.
Because, I mean, a conservation area sounds like a protection area, usually a wetland. But would you want the wetlands in an easement? Did you, I don't, that,
I think it was, quite candidly, I think that's boilerplate for a plan that does have easements. I think the intent of that was that if it's not maintained, then the town can come in and maintain it.
But that should be, those areas should be designated on the plan.
They were actually designated on his
the new
page
plan
4.
has the basins. The question,
Whoop.
when it said
Okay.
conservation area, that sort of threw me compared to easement, because a conservation area is a little different, it makes me think differently than, I mean, if it said drainage basin,
Yeah, I think that was probably the terminology, the intent of it was towards the drainage.
I think it
basin.
wasn't, and at the time, we also had discussions on this plan originally for recreation areas incorporated in it. I mean, they were looking for these large buildings, and we wanted to make sure these large buildings didn't start to encroach and move into other, I mean, there was a lot more need for control because of what was being asked for.
so to cut to the chase on that one, I guess, so the easements that they've shown on this, that's the basins, I guess, is that's what you're looking for, is that?
Yeah, thank you.
Sounds like what you're looking for.
Was there more conservation areas, Ed, when you were?
Not my recollection is that there was some issues with
Something in,
with the large buildings which are up where the hill is going to be removed. And if you look at that, I think if we go back to that original plan, you'll see that there actually might have been some conservation easements. But the main issue here, I think, was that
These basin areas.
that the basin areas and that imposed in favor of the town's conservation commission, providing that these areas shall be restricted in perpetuity. Just that these areas can't be then wiped out later. I mean, they have to be maintained and.
so that's a matter of,
I actually drafted one, and I did email it, because I saw your email to me concerning this issue.
Yeah.
I drafted it, and it references these basin areas.
Okay.
And, I'll send that along. I don't know if I should send it to
should go to
Neil?
town count, well,
Should I send it directly to Mr. Toomey?
I think so, because I'm not going to approve any legal description of anything.
This is the same form
No.
that has been used for
Yeah.
similar easements in the past. So I will send that to Mr. Toomey, but, I think I have clarification as to exactly what we're supposed to restrict now, so
Right.
I'll do that.
Okay, that's
I made
great.
reference to this plan right here.
Okay. So I think what we're saying is these.
Once the plan's accepted,
Yeah.
these are
these are
defined, and these have to be
Yeah, as long as
declared
nothing
as.
changes on anything else and those easements protect that specific area, we're good. Okay.
Okay.
I have a question. What is the recharger area?
Well, what he's considering is a retention situation where you're recharging, where the
Right.
stormwater is infiltrating into the ground. These are designed to do both. In other words,
We have this in the upper corner, at
In the
least on
plan,
this
that's
plan.
not there, but in the
Oh,
other.
you mean the.
Yeah.
Yeah, that's an underground, that's a Caltex underground that we're doing. I don't know, did you want, we could put a restriction around those, but this is an underground system that's recharging up here.
Right,
Outside the
so
wetlands,
shouldn't that be a conservation area as well?
Well, it's not related to any wetlands area, in that it isn't, it isn't part of this Wetlands Act and these basins, because it is underground, there's no wetlands in this area. I don't know if you wanted that, we could put a,
Well, it just jumped out at me at this,
Every other basin, it probably makes sense to have all the drainage.
Yeah, that's-
We'll put that on there.
we can have it.
You couldn't build over that anyway, could you?
No, it's underground, so it's not.
Yeah.
You wouldn't,
There.
Dick, the question was, you wouldn't build a building on top of that.
No, you can't, you really can't.
So, all right, no, it's fine. You add that to it, that'd be great.
We'll do that.
The next one, I think the board does need to make a change to the decision. This relates to there was an emergency access easement initially in the plans, and now there isn't.
Okay, could you give us a fill us in on that a little bit better?
That's number 35.
I know.
And so what it was, yeah.
Oh, the stone wall.
Well, there were two roadways in, I think, initially. Or there was, one would be an emergency with a gate, and the other was the main road.
All right.
But that's gone now, so.
I spoke with the fire chief this morning, and he's okay with this.
Okay.
He did not recall any discussion on it from our initial meeting some months ago, but he's not concerned with it.
Okay,
The
so,
language needs to be just taken out of there, perhaps, modified.
Language regarding
Long
the
way.
second egress,
In
in reference to the second egress.
number 35,
Yeah,
the
35.
stone wall and Stockbridge shall be rebuilt after
So-
construction is complete,
not
except for
building
the
any
portion
stone
needed
wall?
to permanently
No,
remove.
the stone wall's there. Hold it. But there's only one exit, not a second egress now. So
They were going, when they rebuilt the wall, they were gonna leave a gate in a portion of it, so that you could get out, because there was that dead-end secondary road that came in.
okay, so we don't need that anymore. Okay.
And, I mean, the next couple. I think-
Stockbridge is a,
Historic road.
yeah, a scenic road, so it has the, you have to approve the stone walls being removed or taken, or replaced, et cetera.
Okay. All right, so where we're at, 36?
Yeah, I think that, that required a review by the fire chief and probably, I mean, I assume that you'd want some sort of written, something from the fire chief that everything's okay. I mean, verbal is okay for that access thing, I guess, but I think ultimately you might want something
I
for
would
the file that
That's
says.
part of the permit process, would he sign off on that, the fire
He
chief?
does, yeah.
Yeah, so that would be
Yeah,
addressed.
fire department has to sign off on anything over two-family dwelling.
So do you think he needs to do that ahead of time on this one particular?
I mean, we can ask him
issue?
to do a memo.
I think you might want it before the
Yeah,
road gets built,
yeah.
because if he comes in with a fire truck and the road doesn't work, I mean, I guess he could find that anyway, but,
Yeah, I mean, the plans would go to him as part of the permit,
yeah, so he should.
to sign off.
Yeah, sure.
I think that's your 35 and 36 are the same situation. You've got the fire department.
Yeah,
They're actually 32, 35, and 36 are a concern for the fire department's review.
and
Not
then-
32.
Well, 32 because of the,
Egress.
oh, no, I'm sorry, the egress was,
Eliminated.
that's 35, I'm sorry, 35.
35, 36.
Yeah. So 39, the last one on my memo here is the, I mean, when you have a landscape plan, it's usually a landscape architect, I mean, it does, that's sort of implied, but I guess it's up to the board if an engineer is sufficient as a landscape designer.
Well, what's the landscaping plan that the applicant has proposed?
This one here.
What number, please?
Page number?
15 and 16 show details. And yours are better because it's in color.
So the trees along here, and then the next page shows the type of trees.
Well, I have to tell you, I think it's pretty vague, you know.
What is the permit?
I don't know.
There shall be trees?
There shall be trees, you know.
There shall be light. There shall not be light, there shall be
Bunch of green
trees.
little dots that are all the same.
They'd be bigger on a bigger set of plans.
Yeah, I'm sure they were.
Bigger trees.
Well, this is pretty, the cul-de-sac plantings are pretty specific.
John, did you find these plans pretty common in projects like this that you see?
Something like this, a 40B, I've never seen an engineer final landscape plan be done by an engineer. Especially something this size. And you don't go to a dentist to get a knee replaced, you know. I'm an engineer too, but I wouldn't propose that I could design somebody's landscape.
All right, so what does it say?
I think one, you know, and I don't know what their plans are as far as cutting and, you know, clearing to put that access road in, But I think Stockbridge Road's a scenic road, you know, got neighbors across the street, and I think, you know, it's a development that can be screened from the road, like Wheeler Park, and I think that is important that we, you know, maintain that opportunity
Yeah.
to at least do that. What they do inside, you know, is, I'm sure they'll do nice things inside to rent the apartments, but it's really, I think, screening that's, we should be concerned.
Well, I think the challenge I have is that there's opportunities to be more specific in the entryway.
Yeah.
And I think about, Wheeler Park's a great example. When you come into Wheeler Park, you bend around, and this has a curving road, and if proper plantings are done, it can be attractive and well-screened. Even Kent Village, the same situation. As you go up Kent Village, it's attractive from the street. You don't have a clue as to the intensity of what's up and back.
Right. So are people suggesting that there should be a registered landscape architect to do a more detailed plan?
I would support the concept that this is a conceptual plan as opposed to a landscape plan. I also support the concept that our approval shall not be unreasonably withheld.
Absolutely.
But I just think we need to be clear on what's intended to be there.
Yeah, I mean, I think it's a huge issue.
Do you want us to have a landscape architect prepare the plan at the entrance?
Well, I don't think
I
we're
think that's where,
limited to the entrance.
I think that's where our,
I'm just trying to kind of compromise and say, okay, we'll get it.
well, you've already got this basically here. A landscape architect could take this and say, that's great, there's my blessing, you're all done. But a landscape architect could also come in and say, you know, if you do this or this, you're going to have a better project. So you're basically looking at contracting a landscape architect to review what you've submitted, maybe
Provide greater
beef it up a
detail.
little bit and
Yeah.
provide greater detail.
I mean, it's going to be ugly if you just put a bunch of trees in a line. All you have to do is take a look at anything Frederick Law Olmsted did, and it was just like stunning. Not
Well,
that
in
I'm
addition, you might be able
suggesting you
to
did him,
list type of trees and size, those
Yeah.
type of things, too, to be a little more cover on.
That's not on there, Dick, the types of trees and size?
And she talked already, is that specific to where they're being planted.
Yes.
But I think you have an awful lot here. You
We have a
probably,
series.
yeah, you
Show
got,
different types of trees, but we don't show,
Where?
right. A real landscape plan would be much more specific than that, and it can make all the difference in the world, you know, so.
But getting back to Mr. Galvin's point, I think the front entry is a...
That's where we're going to be most concerned with our approval not being unreasonably withheld. If the front entrance doesn't meet any kind of screening requirements, we're going to be concerned, and that would not be considered unreasonable, I don't think.
Right.
But again, you need to know how many plants to buy, which ones to buy, and where to put them in. So you're going to have to draw this plan eventually.
I think what we're proposing is, you know, around the entrance, we're going to have a landscape architect come back with a plan.
Well, I don't want to limit it to that personally.
The rest of it is all privately owned inside.
But we still need to know what trees you're going to plant where.
Yeah.
And you need to know how many trees to buy. You need to know where to plant them. So eventually, you're going to have to draw that anyway. And it needs to be specific enough, not just say, oh, we'll put some trees along here, we'll put some trees there. We need to know density of trees, and we need to have a plan that Neil or John can say, yep, they met their commitment to us, or didn't.
All right.
So.
All right. Mr. Chesia, any, obviously you have to review plans that were just provided to you to see what else is good. Is the main issue, do I understand still, is the main issue is that whole stormwater drainage?
Number 11?
I mean, that's certainly a big one, because that's a lot of, I mean, if you look at my original letter, there's quite a few comments on that aspect, and depending upon what the pleasure of the board is relative to that, that can certainly be a factor as to look at. I mean, nothing new has been submitted relative to those drainage calculations or anything, so there's nothing more for me to look at. But if comments that go out there depending upon what the board.
Well, I think, were the two,
Well, can I go back to maybe, can I explain the context? The plan when we came back in wasn't to redo the whole stormwater detention system. Okay, it was to change the type of units, change the layout of the project. It wasn't intended to start from scratch to, and I think that's pretty clear in the request of the modifications, okay?
But where are you
But it-
suggesting that that's happening now?
Well, I think what John might be suggesting is that if you comply with today's rules and regulations, there'd be a different set of, the design will have to change significantly further, right, John? There'll be some more elevation in the
I
basins.
think so, yeah.
I think his basic concern to, in the stormwater plan was to do the perk around the basins to get the water level to see if those are going to be.
There's two pieces to it. I think that if the board decides that it's the policy, you still have to have meet certain requirements. I'm not sure how much, I mean, DEP approved it, but I'm not, when they write as a thing, you have to comply with stormwater management policy, I don't know what they did. I asked when I first looked at this if I could have a copy of the original calculation, so at least I'd have a basis to compare with, but they wouldn't provide that. Or they didn't have it, or they didn't provide it, so I asked for it. Yes.
We gave you the hydrocarbon report.
You didn't give me the original approved one, which is what I asked for. That one.
We did change the stormwater plan in 6 years. So the hydrocarbon report you've got is the hydrocarbon report.
Well, you said you changed it. Because you changed the pipes, and you changed what?
We changed one
You
pipe.
changed
We changed one
some
pipe.
areas reflected the current plan.
Well, I can give you the current hydrocarbon that shows the reduced flow.
That's what you did.
But the hydrocarbon that you had when you reviewed the first set is the hydrocarbon. I mean, that didn't change. That didn't change. So the only change that we did for the DEP amended fine water conditions was one pipe over here. Instead of going this way, we went into this basin. That was, it's just an easy construction situation. It didn't have a big impact. It wasn't taking a lot of flow. And that's the only change we made in the entire stormwater system. Everything else stays the same.
Is there an issue that you can't give him the plans he's requesting for?
He's had, I'm telling you.
I don't have the old, I mean, I don't have
He's
the original
contesting
plan
the
to
fact,
compare
he
again.
thinks that the hydrocarbon is a printout that's about that big.
Yeah.
And he's had that. He doesn't think he has the original. That is the original.
Back from 2000, from 2000?
No. I wasn't on job until 2004.
But what do you,
I guess what I was hoping to see is, the plan was permitted by DEP at some point in time, back whenever, and that's what, so there should have been a set of calculations and plans that went with that original approval. If I had that as a set, then you can look at it and say, okay, here's what was done, here's what was approved, and here's what's now. When you have one set that says this is this, I have nothing to be able to compare with. I don't have the old plan, I don't have any of that information, so I can't say what changed or if it did change.
Mr. Galvin, can you get in that?
I have the original, or the final order conditions, and I see things that are referenced. I wasn't involved in this project at this time, I think.
Right.
Maybe even Mr. Cole, I guess he was involved at the beginning, but I don't know where any of these real old things are. I mean, we're talking about a stormwater management system maintained and outlined and operating its maintenance plan, June 25th, 2002.
Who would have those then? Somebody must have them. Do you know, Neil?
Well, the zoning board would have maintained records. That was their duty back then, sure.
Okay, so somewhere in an old file?
Yeah, I mean, just to, I know you don't want to get into a lot of detail, part of my concern was, I know.
We've got several boxes probably downstairs, yeah.
I mean, before this place was built, when the first thing came in, it was all woods.
Yeah.
But the calculations indicate that it's like, cleared brush under the existing case. So I wanted to go back to what was the original, so I could have a basis to compare against. Because it certainly wasn't brush when the place was first submitted.
the project,
When you look at an aerial map, and back when this was new, it was cleared as part of some process through the permitting process, and the calculations seem to indicate that that's the condition that was used as an existing condition, and I don't know if that's appropriate. So that was one of my questions.
right, yeah, I think your point is very well taken, because this property was a wooded area when we started the project. It was permitted, and construction began, and it became denuded. And if the calculations that you're talking about are post-clearing, then I agree, you can't do an evaluation of pre and post if you're starting with post-clearing. It would be like my saying, you know, that lot is not going to perk because the water table's too high, and then I come in and fill it over the next 20 years with no one really being clear on that, and all of a sudden I say that lot's fine because the water table's much lower.
Getting close to 20 years here.
That's kind of my point. This project has changed a bit, and the permitting, we have to go back to what we intended when we started, you know.
That's one of the things that that's what I was looking to see, and those are the original ones. I don't know if they're the original ones post to the clearing or whatever, but again, it should go back to what it was raw land before the permits ever started.
Okay, so I think we've thought that there probably is some plans in the basement of the town hall.
The box is actually in our office.
Oh, in the office, okay. So you know what you're looking for, so maybe you can take a peek
I can come
and,
by and take a look.
okay.
But understand that, a whole different project, different engineer, different design,
Would-
nothing like what we did. We didn't get involved until 2004, the first plan was submitted in 2006, I believe. And so if you're looking at something in 2002, it has nothing to do with what we're proposing.
But you picked up- but
He
you
wants to
picked up
see
your-
something, and I want him to see it,
But you picked up the special permit, and the special permit references those original things.
yeah.
So if our consulting engineer is looking to understand what the original was, then it's worth looking at. It doesn't matter when you picked it up. You could have just come on the job in 2009 or 2011, and it's,
Well, it has to relate to the design of the project. I mean, the design of the project is different than. So
but the design of the project has to also relate to the project prior to development.
The conditions under which we did the pre-development, post-development was before it was denuded, because the activity of construction happened after we had those plans already in place. So the excavation of and putting in of these basins here, which was the activity that went on, happened based on our plan. This was our plan.
That's just our consulting engineer just simply has to be satisfied that that's.
And he should look at the HydroCAD that we produced, which is a computer model, and we gave it to him.
Anytime someone says you've got all you need, and someone else is saying, I'd like some more, then I get nervous. I would like the consulting engineer to be comfortable that he has what he needs.
It gives him an
And without
opportunity.
being told, this is what you've got it.
As long as we don't get diverted into a different situation that has nothing to do with the project, which the other information is.
I would like to see this project completed, because I think the naked land that's there is not very attractive, and I don't live far from the project. So I'm not trying to stall this, I'm not trying to delay it. I'm simply think, when someone is asked to consult and look at something, and they ask for material, there should never be any discussion of whether you've got it.
He's never asked for that information.
Okay.
It doesn't make any
He's asking
difference
today.
anymore.
He's asking
I
today.
agree with you, it doesn't make any difference. He's asked for it, we'll give it to him, or if he can't find it.
Well, he knows where he could probably get it now.
Okay.
I can't give him the 2002 because we had nothing to do with it.
But he may be able to get it from us.
I'll come here and look.
Okay, Mr. Chessie, anything else?
I just want to make just one other just clarification thing so that everybody's on the same page.
Okay.
My charge here is to look at the decision for the drawings, and then also to look at the drawings so that there's enough information, so when I go out to monitor and whatever, I have everything I need. And if I see things that I think are incorrect or inappropriate design, I'm going to comment on them, because I'm going to be out there trying to put it in, and if something doesn't look to me like it's going to be constructible, that's what I'm going to say. Now, I just want everybody to understand that. I do a lot of this, I go out in the field a lot inspecting, I see a lot of these things. So I'm very particular on the front end, because it saves everybody time and money on that.
It's valuable because we have experience of a project that's being constructed now, where they've come before us a number of times for more clarification, with the neighbors being concerned, and there's no question, before you put a shovel to the ground, which obviously it's already started here, but it's much better to know what we're doing, what's intended, and have it clarified now, rather than try to fight it out later with angry neighbors or someone else. I mean, we can't control others' actions with respect to stopping construction, for example, if there's a dispute.
And, you know,
Let's
we
not
wouldn't-
have any
we would-
disputes.
I wouldn't
Let's move
even have
forward.
raised the issue if it said that the, you know, the town's consultant shall review it for general constructability. I wouldn't have raised it. He reviewed it, we have the benefit of his comments, I think we tried to
lucky.
incorporate them in. I'm okay. Okay.
I think we do have some concern, and I know Mr. Jesse is a very good engineer, but unless he's the supervising engineer on the project, he starts changing things out in the field. It's his job to make sure that the
He doesn't have
construction
authority.
goes in compliance with the approved plans.
I think that's what
That's
he-
the limit of his impact. He's not
I
going
think
to
that's what
change-
Mr. Jesse is looking to do now.
But he'd rather know that the approved plans are constructible. That's the point.
I mean, I've been in this business 40 years.
Not questioning that.
Okay, you know, when you go on the states, you know, the trails, you know, Clark Estates, that's my design, that's our construction. We do this as a matter of fact, okay? Mr. Chessie's a very good engineer. He knows he can't step over the line, otherwise he becomes the design engineer. And I would want his stamp on any drawing that he wants to change, because I'm not going to go along with another engineer's design, which I might not feel comfortable with,
Right.
okay? Understand that.
But please understand, we're not questioning your integrity or your skills or your stamp. We're simply saying that if there is a concern, you could have an oversight. You could have someone, you know, Mr. Chessier or someone else might say, could you review this? And you could say, oh, that's a good idea. That'll make it easier.
And he can come to me and say that.
And that's,
He has
and
no
I
right
think,
to tell the contractor to change.
no, I don't think he's suggesting that. He's suggesting clearly,
He's not.
what he said to us tonight was he
He's not
wants to,
suggesting that John can tell the contractor to do
If I
something.
see something that's not constructible.
in the plan.
He's talking about the plans,
In
he's
the
not talking
plan.
about on the ground while the project's.
No, he's not, he wants to, when he goes out there to
He's
see the
working for the
plan
town,
being
essentially.
completed, it needs to be completed in the way the plan was drawn. If he sees in advance that that's not gonna work, then he needs to bring it up now before you go out in the field and then see something that can't be constructed, because then it has to be
He
discussed.
has to bring it up to the design engineer. His rules and regulations.
That's what he's intending. That's what he's saying. That's exactly what he's saying.
Dick, enough. This is not productive.
Neil, do you have any comments?
No, just very quickly, you know, in the, I know in another 40 years going on, any field changes have to be authorized by the zoning board. I think in reality, if field changes are, you know, if the engineers are working together and they make minor modifications, you know, there's no need to spend 2 weeks, you know, waiting for hearing and
You know what,
everything else.
John
Agreed.
John
You
is
know,
the review engineer in Norwell, and he actually approves field changes unless it's something that's material, and then he sends it back to the board, right?
Yeah, I mean,
Our monitoring engineer isn't in a position to supervise contractors, to instruct anybody to give out orders. If issues come up, I think the board should be comfortable enough letting the two engineers work together and say, okay, you know.
I hope they can,
10-inch pipe
because,
instead of 12-inch pipe.
That would
or
be
8-inch
good.
pipe, so that's the way I like to see it going.
yeah,
If
absolutely.
there's some way to resolve this stormwater thing, it doesn't resolve the issue with the Conservation Commission, but it
Okay.
resolves how we go forward.
So,
Review finishes or doesn't, and,
yeah, well, so
And
I
I
guess that's our big issue, right?
I mean, I can tell you, because I was involved when this last modification came in, and I think maybe Mr. Tippett was on the board, and maybe you came in at some point during the proceedings. I have some memory of it.
Yeah, it was.
You know, the reality wasn't to change the stormwater design, it was just to change the units.
Right.
And if this is being interpreted that way that it was intended, I can tell you that's not what it was intended. And I do see the language that Mr. Cheshire's referring to, and I understand why he would say what he said, if he sees that.
Try to help me understand it better.
Right.
We have the original plan that was approved.
Correct.
We had a 40B approved for those buildings, you know,
Right.
all
And it
that
was
stuff.
the duplexes and some rentals.
Duplexes and the big buildings and the whole thing.
Correct.
What was the terminology used in that decision? I don't have it in front of me. Was that decision policy or
You're
regulation?
talking about the original.
You know what?
Because
I'll see if I have.
here's my point. If originally the decision that the board came to after months of hearings, and I know most people were involved in that, if that decision stated regulation as opposed to policy,
I have the permit.
and then that terminology continued on, and then basically that's where I want to be talking from.
I think I can,
I'm willing to consider changing it and finding it to be insubstantial. However, I want to know what changing it gives up or gives away.
let me just see if I can, I have the
Does that make
original,
sense?
I have the original permit, so I think
Yeah,
that's a
makes
fair
perfect sense.
question.
Is this the one, was this the
This
original,
was the-
two big buildings? Was that what it, originally?
No, this was the, you were asking about the
One big
original-
building, which became two. I think we became two before we approved it.
You know what, there were like a lot of like letter modifications, and they never changed the original terms and conditions. It's because they were kind of lesser than changing the whole project.
Exactly.
So let me tell you what it says. It just basically said that the project as approved shall not increase the peak rate of runoff in the 210, 2,500-year storm events as a part of the as-built approval required by condition 51, registered professional engineer submit an as-built plan on the entire drainage system. In addition, the engineer shall certify in writing that there's no increase in the peak rate of runoff in the 210, 25, and 100-year storms. The area to be included in drainage calculations used for the certification shall be the whole drainage area contributing to runoff to the site. And then it says, and there's no mention of there's no
Policy or
mention of the
regulation.
policy or regulations,
Okay.
because they had an adjudicated decision from the DEP.
Okay.
Which
And so they're repeating what was in the DEP
this doesn't.
decision right there, right? What you just read.
Well, I think those are policy standards, aren't they, John?
Actually, I think it goes a little past what the policy says, because I think the policy.
But we're willing to live with that. I mean, this is what the original thing was based
But
on.
this doesn't say that. It says regulations.
Right, but that's the modification that we made. Right? That's the but that reference that's the modification?
You notice it's
Yeah.
like,
Yeah.
do you go by the
That's
8th
the,
edition of state building code or the 5th edition of state building code?
Yeah.
Because
Well, it makes a big
that's really
difference,
what
though, in
it's
this thing, 'cause then you're gonna-
grandfathered from the new edition.
Is it the 2008 or
Yeah.
do we, or after
You know,
that?
the
It
way
was issued in
you pulled your
2006.
permit and you've extended it, legally, then you're grandfathered under the old state building code. So
Right.
personally, I think if DEP says policy, or that you can go by what you're grandfathered under, and we say regulation, I think there's a world of difference. And we need to, comply with, I think what's lawful here, and that's.
Well, if we
I
didn't
don't
have,
think DEP makes the board's decision, but I think in this case here.
No,
And
but
it's
the-
under appeal, so,
again,
maybe that aspect isn't.
the problem is, it just, so much time passes,
Lapse.
words change.
Right.
My favorite word in education is, what did we used to call that?
Right.
And I guess that's where I'm getting from, is this, what did we used to call it? What we originally were talking about, that's what we approved, and that's the language we approved. That's maybe even little more stringent than regulation.
Is more stringent than the
Then-
policy.
then
It's only
policy.
stringent in- I think it has one other storm than DEP would require.
Under policy.
And it only touches on, the difference is that touches only on that one aspect of the policy, which would be runoff rate, whereas there's 9 standards.
So the policy with 9 standards is maybe even a little more detailed than the original decision.
Sounds like it.
So if we go to policy, we're staying, we're not giving up anything from the original conditions.
No, I mean, the question again is though, their claim is that if they've got the DEP permit, then there's no need to look at any of it.
Well, it's gonna be looked at no matter what, because it's a conservation appeal.
Well, it'll be looked, but, I mean, in terms of this board,
Yeah. I always think of policies as more aspirational, and regulations as specific, you're going to put A here and B there.
that's exactly what happened. The policy started, initially they came out with the policy, got people, used to it for so many years, and then boom, it's a regulation.
And then probably
it's
originally,
stringent.
when this started, we didn't even have a policy.
Oh, 2000.
We did have the policy.
96 was the policy.
Okay, 96.
2006, if that's when they applied for the permit, they were under those,
Okay.
The
So
permit
they-
was 2003.
2003, okay, so
that's the thing. We were under the,
At some point, if we wait another...
96 was the policy, 96 was the policy, so they were permitting under the policy.
Right, but if we...
But we stipulated a little more than the policy in the decision.
Correct.
And that was dated when?
2003?
Correct.
And then is this the next change?
Well, then they came in and
It
they,
was intended to change the type of units, not intended to change the stormwater design. But now what is potentially coming up is, should there be more changes to the stormwater design, even though that wasn't.
I mean,
What the
why is this completely different than what the permit was back in 19?
I think
well, they had a substantial change in the project by
Yeah.
going from being ownership to being,
But from a stormwater impact, it had a lesser impact than what, I mean, technically, they could go back and build a prior version of this project without building it as a rental project, but that doesn't make any sense. Oh, wait a second, hold on a second.
That hasn't answered my question.
Well, let me just say, all work shall be performed in, there was another paragraph at the beginning, and I missed it. Let me just,
Always say read on, right? Didn't I learn that in law school?
Is this the original decision
this is the
again?
original decision. All utility work shall be performed and conducted with the current with the regulations of the town. Let me see, all construction shall be done to best management standards. Final design of stormwater management shall comply with the Department of Environmental Protection Stormwater Management Policy. It shall be reviewed and approved as complying with said stormwater management policy by the board's consulting engineer and applicants.
Okay. So at the time that was written, did they have stormwater management regulations also?
No, that was in 2008.
All right.
so
So-
that having been said, assuming that all this, ties together, my personal opinion is that using the term regulation here was changing a portion of our decision that really they didn't come before us to change. And I think that you do have to kind of grandfather them in on that. Now, I'm not
Yeah.
suggesting we don't take care of the...
You were there and I wasn't. I mean, I would, not being there, reading it, interpret it the opposite, well, maybe not the opposite, but I would interpret it to say that, okay, now we're in 2012, whenever this was, and the regulations have changed. There's no longer policy, there's now regulations, and we want this to be built to current standards, so we're going to call them regulations.
But just as a matter of, like in 2009, 2010, did they even use the policy anymore?
No, once the regulation came out, boom, that was it.
Right, so I think the question
All
still
the permits
Except for
becomes,
existing permits, right?
at the time, did we want them to, when we started, or when the project was started, did we want to follow those current policies at the time? Because the name change, the same thing, it gets back to Neil's point.
Housing Appeals Committee would look at the
With building
economics,
code,
and then
They have new addition, but the permit's already
Well,
started.
that's actually not a
When
bad
do we-
thought.
Yeah, I hear you there.
If
yeah.
we don't finish this up and the appeal goes on another year, another round of regulations goes out, then it gets, there's enough, so you gotta, where does the clock start ticking? What point do we go back to give him his information so that he can review it? That's what he's really looking for, he's not.
I can't honestly remember whether or not we raised the question of stormwater regulations versus...
I don't think we did, because
Did,
I'll
because
tell you,
they're not in
there was 7 modifications we requested the last time. Change the style and location of the units, to increase the number of dwelling units from 68 to 74, but reduce the bedroom count from 156 to 48, to convert the entirety of the remaining single condominium units to rental units, and amend the existing comprehensive permit to make its language internally consistent for the new project, to eliminate a restriction against vinyl siding, allow a new entity to be involved, and to delete the conditions that were inconsistent with the then recent ruling by the SJC. Those were the ones that were changed. It wasn't to redesign the stormwater system.
Does anyone recall who drafted this?
Jim Toomey and me, and me.
So I
Yeah.
just.
We accepted what we were given to
Why
accept.
in the regulation?
I'm just being honest with
Why
you.
the language
That's what I'm saying, though. I don't-
Regulation.
I didn't-
That doesn't seem to have been a subject of modification.
It doesn't sound like it to me, but
Yeah.
they drafted it
Oh, okay,
and gave it to us to approve.
all right.
So from my
That's how it
perspective,
changed,
it changed. because they requested the change.
All right, there you go. That's my answer.
If I had drafted this, I'd say,
Well,
okay,
I
maybe
mean,
I misinterpreted.
I guess we could come
the
in and
intent
we
of the
could
board.
submit a further request for modification.
But that's my point, is that I want to know why we're changing it, and if we're changing it, and I didn't draft it. That's my problem.
Well, I
mean,
think-
I thought
do
maybe
I
you might say
understand
Peter Moran drafted it, and I'd say, okay, Peter, why did you do this? But he didn't. I mean, it's,
I'm not suggesting that he did. I mean.
no, I know, but it puts me in the position of saying, I'm not an attorney, but something about if there's an ambiguity, it goes to the person who wrote the contract?
Well,
Against them, yes.
Goes against them?
but not when it deals with permitting. So.
I know, no, but I'm not trying to point fingers, I'm just saying,
No, and I'm not
explain to
suggesting
me
you
why
are.
we should change it, but we have to change it because someone else changed it and asked us to approve it that way.
I completely get that.
If I understand, the current design does not comply with regulations. Okay. Does it comply with policies?
I don't know, I didn't look at that.
Okay,
And I wouldn't be able to know until the soil testing is done at the specific location.
correct, all right.
And keep in mind, a lot of this infrastructure has been constructed already.
Right.
In
Has been?
accordance with, the regulations in effect at the time, right, John?
Well, they got basically the two
Presumably.
crossings.
They were signed off by CEI, I think, the work.
Okay.
But it would seem to me at this point, John understands, or I think you guys both understand what the quandary, at least I'm in.
I wasn't aware until tonight, but I'm glad to know that.
But now I think it's more clear for all of us as to what the issue is.
Right.
And it would seem to me that the engineers and you guys can get together and decide how best to handle that. I mean, what's in place today that may or may not comply with regulations versus what complied with policy, which was,
But John's ultimately going to say back to you, complies with policy, doesn't comply with regulations.
what I would like someone to come back to me with is, this plan will comply with this terminology. We'd like to modify the decision to change the terminology so that we can have a plan that will meet the terminology.
Yeah, and
In
that-
doing so, you're giving up this and you're gaining this.
And I was thinking what might make the most sense is to say, look, why don't we comply with what the DEP requires here in the end? And that's not, the subject of whatever the.
So that's the terminology. Change the terminology to say to comply with the DEP's decision.
Correct.
If that's the case.
Right.
But what are we giving up by doing that? If what we're giving up is the Conservation Commission's
Well,
stand.
you're not giving up their appeal, because their appeal's on a
Okay,
completely different issue anyways.
Explain that to me so that I understand it,
Yeah,
and then I can,
no.
then I can vote.
What DEP, what the commission is claiming, and I've had conversations with the agent, and very pleasant conversations, he's claiming that the changes to this project don't comply with a proposed Zone A map change
Understood.
that are coming in. And what I've explained to the agent is that the 4 changes that came into play here are, 3 of them relate to a net reduction in impervious surface if you have less stormwater going into the originally designed basins, okay? And then the 3rd change actually redirects some stormwater from one basin to another. Those were the 4 changes that really DEP was asked to say yes or no to it, and they said yes. Now, my understanding in speaking with Mr. Gallivan is that there's a concern that groundwater impact wasn't considered at some point, okay? Well, it was definitely considered by DEP at the beginning, and it was definitely considered by the town, because there was a judgment of the Department of Environmental Protection. This is okay. And it clicks off as a protected interest, groundwater supply and groundwater quality. These are checked off boxes on the original.
Which is a fairly high standard.
Well, it tells you that they were considering the impact of groundwater, in every respect. So the question now, DEP is going to ask them at a pre-hearing conference in 2 weeks, is how do the changes in these plans impact those issues? And I think what I've heard so far is that they're really not concerned necessarily with those issues. They're interested in groundwater impact because there's a potential change in a zoning map that's under consideration.
Can't
I have
imagine
to
that's
speak to
going
that. And correct me if I'm wrong. I believe this development was requested and was exempted from Water Resource Protection District regulations.
I don't think so, because he's showing him on the plans.
It was exempted according to the decision. That's
Yeah.
what it said.
From,
Section 500. according to
yeah, it was,
Section 500.
all right. It was, I,
You want to hear another one there is some ambiguity here. The applicant should comply with the superseding order of conditions issued by the Department of Environmental Protection, January 5th, 2007. It's actually the final order of conditions. So this permit says you got to comply with that, okay, and the regulations. And the original decision said policy.
Patrick?
So,
Pat Galvin, Conservation Agent, sorry I missed the first 10 years of this.
no, you're not.
But the commission is interested in two things, the stormwater issues and the drinking water supply. It's not just the groundwater supply, but it's the surface water supply, and there's a stream coming through there. If this new map that's out in the hall goes through and the zone A is expanded, the stormwater structure that's there now wouldn't have been able to be built. So we understand there's been a permit already issued. We just want to make sure that the drinking water supply is protected. So we're questioning the DEP decision. We know they haven't been out there. And as John's study has shown, they haven't done test pits everywhere where these detention basins are going to be collecting stormwater. So they may say, nope, it's already settled and there's nothing you can do. Or they may say, gee, is there a way we can improve protection of the groundwater? And that's all we're doing. And we're happy to meet with everybody next week and do a pre-hearing before the adjudicatory hearing and work something out. So that's what we're doing.
I don't know, sort of my experience with the law is that you're not gonna get too far on something that hasn't been implemented yet. You know, that might get passed, but,
we can't comply prospectively with
Yeah.
a law that doesn't even exist yet.
right, exactly, that's the problem. You know, so I just can't see that one going anywhere. My concern is that, I guess I kind of go back to what you said in the beginning, is that if we state policy, is there some specific regulation that we're gonna wish we should have complied with?
Well, I mean, I think if you want to, I mean, in my initial letter, it goes fairly detailed into where I think it doesn't comply with the regulations. And if it would be, if you'd like to talk to me about it, if you want to read it and have questions, if you want, whatever you want to do, you know, let me know and I'll try to explain what it all means, however you want to do it.
I think the thing is that I wouldn't be opposed, you know, in sort of concept, I'm not opposed to changing regulations to policies, except that, again, I'd like to know, is there a good reason not to? You know, are we endangering our groundwater supply by, you know, this particular instance by not complying with regulations?
I have to think that if DEP had changed the policy to the regulations, they did it for a reason, and they increased groundwater separation for a reason, because they found that as time goes by, you learn things, and
Absolutely.
if you learn those things, you would have policies and regulations to change that. I mean, years ago, you would just take a pipe and you dump it right in the stream.
Correct.
They realized that probably wasn't the best thing. So since then, you know, they keep, and I wouldn't be surprised if in another 5 or 6 years, we get another set.
Right.
With, okay, these types of things haven't worked so well, and these things have. So this is what we're looking to do. I know they're pushing more of these low-impact development design techniques. That's gonna be probably the next thing you're gonna see. So, yeah, every time they do something, it's clearly done for a reason, and it's certainly better for the environment, I have to presume.
Right.
I think it's more of a legal question than, if it's what's the best for the environment, certainly you go by the regulations. No question, it's gonna be better.
But at the same time, I think we're talking about if certain infrastructure has been built based on an argument of policies.
There's a certificate of compliance.
Right. You know, are we now creating a situation where they're gonna have to make significant changes that, you know?
Probably, I think based on, well, without having the test bits, I can't say for certain, but I know that for infiltration, which is what they are proposing, you'd have to be 4 feet above the water table versus 2 feet.
Yeah.
So I think that the underground one, probably, it's up on the hill, it's probably high enough, but the other ones probably wouldn't meet that. So that would mean you'd have to come up 2 feet. Would that affect all the way through, moving the road? I can't say, because I haven't tried to look at that. But if you had to raise the basins 2 feet, say, and that's presuming that they currently meet the 2 feet separation, if you had to raise them 2 more feet, then probably everything going into it would have to come up a little bit, which means the roads would probably have to come up a little bit. The basins may have to move back a little bit, because you're not gonna.
Maybe they just have to move the inverts up on the pace, on the,
Yeah,
on the catch basins.
You could make the cover very little, I suppose. I mean, there's lots of different things, but I would have to think that that's probably what would happen. Stuff would have to move up and possibly move further back from wetlands. There's some other things in that. I know that you'd have to be a certain distance from a vernal pool. You are supposed to be a certain distance from a Zone A. And relative to the Zone A, I know the town is mapping its water resources thing, but I mean, a tributary to a water supply is actually defined by the state. It's not, the town may be adopting a thing, but there's a state regulation. Here is what it is. It's the bank of a stream that flows to it. If you look at the Mass GIS, it maps it right now as a Zone A.
Is that a
But it's not a
stormwater
zoning-
regulation?
It's not a zoning regulation yet.
It's not, no, it's a state regulation.
Which would kick in anyway.
I have one more comment too, just on the WRPD exemption. If someone, and that would be me and Bob, if you want to look at it too, but we need to look closely at what exactly you are exempt from under the WRPD, because a lot of the stuff we're talking about tonight, the detention basin, we have requirements that you can't have more than a 1 in 2 slope, is it?
Probably 1 in 3 or 4.
Yeah, 3 or 4 slope, and they're much steeper than that. So we need to determine if the board did actually exempt, and keeping in mind, we're going back, almost 15 years here, so.
Yeah, and, I'll tell you, there's a part of me that, despite being, very concerned about protecting our water supply, feels like, boy, this has been going on. If this creates an incredible financial hardship for the applicant, I don't know. I don't know that I could get on board with that.
I'm not in the least trying to suggest that
First time I hear something, leave it on us. I mean, that
Just keep it under $50.
half a million dollars to cross 2 streams.
Yeah.
Our only
And 14
interest,
years of
our only interest is
aggravation,
protecting the
please.
town of Scituate water supply. There's a tributary there, and you look at there's a map on the wall out here. It's a state tributary, state identified tributary that flows into our water supply. And we've got construction going on all around it, and it's got to be protected.
It does.
And that is my only interest.
It was a
frankly.
stormwater prevention,
Can I just put
pollution
something in
prevention
perspective
plan.
here? We all know that the Scituate MBTA station is sitting right within a few hundred feet of what we call the water supply. Okay, that's primarily pavement. Okay, they did that under the regulations. My client is Scituate Concrete Pipe. I designed a drainage basin for them while that was going on, under the regulations. Okay, things have, when I hear this thing that, oh, you can't build the drainage basins under the under the Zone A or the current regulations. Well, those 2 structures are within what anybody would call a Zone A. They're in the primary area of the water supply. They're really close. We're 1,000 feet away.
So you're saying you can comply with the regulations?
Yeah, we did, because.
All right, then let's not worry about it. Just comply with the regulations. That's what it says.
No, we already did.
Then then that's what let's stay with regulations. You just told us he can do it. Great. We're done.
With this project, you're saying this project complies with the
No, he says he can do it. He says he can do it. They did it over
No, no,
at,
no, no, no.
Those days, not today's
What-
regulation.
No, we are complying. Are we not meeting the requirements for treatment with the downstream
No, what
defenders, the wetlands?
That's not the
That's
issue.
the
The
case.
issue is the Zone A.
No,
If you
no.
read the regulation, the Zone A doesn't allow you to put certain things, including stormwater.
But we don't have a Zone A there yet.
But what I'm
No,
saying,
actually, the Zone A is a state tributary to a water supply under state regulations is a Zone A.
So you're saying there's a Zone A under the state, in the state definition of Zone A on this property?
Correct.
no.
Oh, that's going to be a,
There's a map right outside. You can
Right.
see it.
There's a map outside and on the proposed regulation. What I'm saying is that the MBTA station and that, all those structures there are within, anybody would call a Zone A by definition. It's not a tributary, it's right on the watershed of those reservoirs. Those were built within the last few years, okay? To say we can't do it, first of all, there's a certain requirement of removal of solids in the basins. We met that requirement under the regulations or under the policy. We've already met that. That's how they were designed. That's why they went through the amended order. That's why it went through the superseding order. That's why it became a final order. You have to meet those requirements.
Then there's no reason for us to worry about whether the
Absolutely not.
the decision says regulations, then you're telling us we can operate under regulations.
Well, that's
I'm
a
sorry.
semantic situation, whether it was regulation or policy becomes, I was a former DP, okay? Policy precedes regulation. And then at the regulatory aspect of it,
But we're being asked to make a change or
We don't
consider
need
a
to.
change that we don't need to, according to what you've just told us.
I don't need
so,
to make a change on the stormwater system.
okay, Mr. Gal.
Yeah, I was just gonna say, we may be able to settle the Zone A issue this week. We've invited the DEP drinking water supply person from the southeast region to come out. He wants to walk it and see what we're talking about with this
Okay.
infinite stream, so.
Okay.
So,
might
all
help.
right, do
That'd
you
be
suggest, do we, because it sounds like what we've just heard from Mr. De Benedictis, correct? Is that they do comply with all the regulations. So your review should go ahead and decide, did they comply, as he states, as he alleges, does it comply with the regulations? And if, maybe that, is that where we're headed?
I don't know where we're headed.
I understood you were asking for clarification.
I actually thought we resolved all of the issues, and then we didn't anymore.
I
So-
thought the concern was we either were using regulations or policy.
And we're using regulations, it sounds like.
And the concern was that regulations might be hard to meet, at which point I was willing to consider changing
Right.
back to policy, if indeed that would help the project, because I do understand how much it costs, and I don't
Yeah.
want it to be a crazy,
But we have a
economically unfeasible.
Portion of the project is already built in accordance with the prior set of regs, so.
But if we're
How
meeting.
we do that?
But if
Well,
we're
that's what
meeting
I'm-
regulations, then we're all set, we don't have to change it. So I
Well,
guess
that-
I'm asking that you guys come back to us with,
Final
if we
plans.
have to change terminology, then I would consider changing terminology, but I want to know what is
What's the
being
difference?
affected by it.
Yeah.
If we don't have to change terminology, then let's just leave that and review the plans based on the regulation.
Well,
So
I
it
think
should
you
go into the import.
misinterpreted what I said. We meet the regulations for quality, okay? Now, what Mr. Chesky is saying, well, the current regulations require 4-foot separation for a basin instead of 2-foot separation from groundwater. We may not meet that. We might be in the old regulations for that, but that doesn't affect the quality, okay? The quality was affected by the way we constructed this, or we proposed the system. It's basically three levels of treatment. There's a downstream.
Convince him.
Yeah,
'Cause he's gonna have to
really,
tell
honest
us.
to God, because we're gonna look to
What I
him.
want to do is convince you that we're not talking about meeting regulations per se, we're talking about meeting regulations.
But that's what the.
That's the
but
only
that's what
way.
the- But that's what but what we're talking about is what the document says. It says, it stipulates that you meet regulations as defined and that are, this is what the attorneys do.
And they only. and
This is our standard, it's right there. It's not what you think the standard is or what I think the standard is or what we can interpret the
It's what
standard
the
to be.
state law says.
Then-
And the DEP is the only purveyor of that state law.
Okay.
That I know.
Okay.
Massachusetts. There's only one.
I guess what I was-
Conservation.
I'm ready to help, but I just don't know what I'm helping with yet.
I know, I may have to figure that out too, so. I think what we were trying to suggest is that it doesn't, meet stormwater management regulations. It wasn't intended to. I see the language you're talking to, but there's also language that says you gotta comply with the order of conditions, so there's an ambiguity there. I was hoping we could sort it out so that he knew what he was reviewing, we knew what we were designing, and then we'll resolve the Concom issue independently.
Correct.
I thought we got 9 of the 10 issues resolved tonight. I was hoping we could get this resolved, and that's what I was hoping to
I
do.
think we're still up in the air.
I think it just fell apart.
I think we'll articulate in what
It's that
respect-
last breath.
I think we'll articulate in what respect it doesn't, and we will request to come back at a future meeting.
Yeah, at least it's going to be more
Well, I
narrow.
think too, we're just on that one point.
Yep.
That
I
seems to
have,
be the,
I have no problem with getting in, to coming to an understanding on this. We
Right.
just have to know what the understanding is.
Right,
what
because
the
I
concept
think
is.
we
I think
need some
that's
very
very
specifics
fair.
about what are we asking to give up.
I think that's fair.
Yeah.
I
We
think
may not be
resolved
giving
8
up
of the
as much
9.
as we gain. It's possible
Right,
we're,
right.
it works both ways.
I had, just on the legal aspect of the request, I note that there was no formal request in writing
Correct.
tonight to make a modification.
Correct.
So at what point does the 20-day clock start ticking, and should we be looking for requesting an extension from Attorney Galvin?
Well, is there any, I don't know that there's a clock
I was just
clicking
trying to
at
get
all.
clarification on some things that were arguably
Yeah.
ambiguous, and I think he got direction. I think once we articulate the difference on the stormwater thing, if we need to come back, I'll write a letter requesting a modification. I'll characterize it the way I think it is, then you can evaluate it and decide what we have to do.
So there's no clock
That's when the
ticking.
clock would tick.
Not on
if
that
it's-
issue.
there's no-
I think you've clarified anything. We weren't asking to modify anything. You've
Correct.
clarified 9 of the 10 issues. We have 1 issue left. I understand exactly what you want. and
Okay.
I'll explain it.
That's awesome.
Thank
Great.
you. Thank you for your time.
You're welcome. So, anyway, Frank, did you get a chance to look at that decision? Are you good with that?
I did.
Are you good with it? You're not.
I just thought, I think the last sentence or two, and it's not a big deal to me. You know exactly what I'm talking
I
about.
know what you're talking about, and you think it ought to be struck.
Correct. But if you really feel strongly, I'm not going to,
Well,
Oh, we got enough.
where do you want it struck from?
hang on.
Thank you.
thank you.
Thank you. Where are you looking at?
Are we
Live.
done with the hearing?
No, because
The
we have to do this in.
the last 2 sentences, the appeal for 141, and then Missy Bjorklund, she can find the last 2 sentences.
Okay, so you're good with the rest of it?
I was.
Okay.
So
This is a
3/4.
discussion on the proposed decision.
Yeah, yeah.
That was drafted, and the
Yeah.
3 board members who are voting will be, are discussing the terminology.
You know, I think it's, I think it's certainly superfluous to it. It's a little bit of a dig, you know, and if
I think we pull that shovel back out.
we could, that's fine. I am not going to fight you for it.
Okay.
All right. So we'll take, so Nicole, did you get that?
Yeah, I'll give it to you.
Yeah, it's just these last, here, do you scramble through it?
Which one you taking out? The whole?
It's the last 2 sentences. The appear, no, well,
No, you had a
not
couple.
the last 2. Because the last one is it's denied. So the appeal for 141 Turner Road is in process. Mr. Bjorklund should confine his discoveries to that case. Just that little bitchy side of me that wanted to
You're on the news.
No. Yes.
Do we have a motion to
I'll probably
adjourn?
be sanctioned.
Move to adjourn.
Second.
Move to adjourn. Thank you.